Yes.
Please, my lord. In item number 1, we want to withdraw it, my lordship.
You want to withdraw it? What happened?
My lordship, we have been granted bail by the Honorable High Court.
Both the
No, Your Lordship.
In
One
item
point-
number 1,
in one.
only one, my lordship. SLP number
1.1
7.
what remains?
Yes, Your Lordship. More than a year.
One has been granted.
Yes, my
Yes.
lordship.
Prakash has been granted.
Yes, my lordship.
That's what?
Criminal revision.
Prakash is the one who's out on bail and he's and he's granted bail and the other man is
No,
not.
no, my
Other
lordship.
man is-
In
Maybe
previous
they
case,
have not filed, the second one may not have filed it.
He might not have filed.
Yeah.
in previous
Because of
case,
that,
he was acquitted by the Honorable High Court.
Very good. Item number
No,
one will dismiss as withdrawn.
Yes.
1.1
Yes,
you
ma'am.
can argue.
Please,
yes,
my
sir.
One
my lordship, may I
counsel for the petition takes permission to withdraw the special leave petition as the petitioner has been granted regular bail by the High Court in the interim. According to said statement, the special leave petition is dismissed as withdrawn.
Your Lordship.
1.1.
I may be
1.1, Your Lordship.
1 minute.
I may be granted permission to file my
Physical
and physical. Please, my lord.
Your Lordship, I am appearing for 1.1, Your Lordship.
Yes.
There is
You know,
no
I filed the
criminal,
counter, but doesn't seem to have any antecedent.
Antecedents.
there is no antecedent, Your Lordship. Bail may.
1.1. And the other man has already been granted.
Yes.
Granted, Your Lordship.
Leave granted. The appellant is agreed by the denial of regular bail by the High Court of Judicature at Madras, the order dated 4/9/2025, passed in criminal OP number 11874 of 2025 in connection with FIR number so and so. Counter affidavit having been filed by the state, we find that the appellant has no past antecedents and the co-accused, Prakash, has already been granted regular bail by the High Court. We therefore find no grounds to continue with the incarceration of the appellant, pre-conviction incarceration of the appellant at this stage. The appeal is accordingly allowed. Setting aside the other dated terms, so the appellant shall be released on bail on
Was it satisfaction of the trial court, madam?
trial
Obliged.
Obliged.
appropriate terms and conditions.
Item number 2.
Yes.
May I please, Lordship? My Lord, may I be allowed to point out just 3 things in this case? First
Yes,
is a long incarceration of almost 5 years. And all the co-accused, they have been granted bail. And my Lord, in this case, what I would like to point out is, for the past 2 years, there has no any production of PW. The last that was produced
Now,
was
3 out of the 9 witnesses have been examined.
yeah, only 3 has been examined, and the
And
last
the
time
seizure witnesses all speak of you being in the Bolero when the seizure took place.
my Lord, I do agree.
About the commercial quantity,
Yes,
1.8.
my Lord, I agree, Lordship. I
With
do
that
agree.
kind of seizure and
Right,
the
right.
fact that the seizure witnesses speak of your presence in the vehicle when the seizure took place.
My Lord, it is not, because
How
PS
do you get over
85,
Section
if I may
37?
be, if
How
I
do
may
you
be
get over
allowed to
Section
take.
37? What about past antecedents?
That we have.
No,
He
no
doesn't have-
antecedent, my
He's
Lord.
actually, Lordship, not from the state. He's from a different state.
He is from a different.
Yes,
Could
also
you verify with the.
one of the, Lordship, I can only say one of the co-accused who has been granted bail is absconding. The things have been held up because of his
Because of
abscondence.
And you've
My Lord,
separated the
if I
cases.
may be
Yes, we
allowed to
separated
point
the
out, both
Yes,
the
please.
both the seizure witnesses have not identified any of the accused persons. That is at page 85 of the paper book, my Lord. It is recorded in the bail order where it says both the seizure witnesses have not identified those accused persons in the dock, and
No,
one
but-
of the seizure.
That is not what they are saying in the counter. Please look at the counter.
My Lord, the counter only, my Lord,
They have, Lordship,
they have
confirmed the
admitted that-
seizure.
Seizure witnesses have named the petitioner
Lordship, it should-
as being present in
It
the
should be
counter.
confirmed, Lordship. The
No,
seizure is.
but it is
Seizure
recorded
is
by the High Court.
Seizure,
But it is recorded by the High Court, page
Lordship,
85.
Lordship, I don't have this one with me.
No counter you don't have.
No, I have not put that. I have
Sorry?
not. No, I have not put the PWs, Lordship.
No, but you said so.
Yes, but
Is
I have
that a fact or is that?
my instructions are, Lordship, they have confirmed the seizure. And the
That is
seizure
not
list,
what you said though.
I know, Lordship, I have seen that it's not worded that way, Lordship, but I'm saying so. The seizure has been confirmed.
That is not enough.
Lordship.
I'm
That's-
going by the statement that
No,
you made
Lordship.
that they named him
Lordship, I have
as being in the vehicle.
Yes, Lordship, I have
Is
seen.
that a fact
My
or is
lord-
that not a fact?
Lordship, I have to that confirm with the other records of it, because the records were before the High Court. And the High Court, Lordship, at para 4. High Court also, Lordship, at para 4 said in this manner only, Lordship, that
Para 4. What does it say in para
Lordship, Lordship, I'm reading at the top of page 4 actually. She further submits that amongst the witnesses examined, there is also seizure witnesses who have deposed against the petitioner. Page 4, Lordship, I'm reading from top and
further submit?
submits, Lordship. That is, I'm from the High Court record, Lordship.
Deposed against the petition.
Against the
That's
petition.
also neither here nor there. We don't know what
Specific.
exactly that is.
My lord, may I
Produce-
take lordship to page 85 of the compilation paper?
You
book?
filed the
Paper book.
positions of the seizure witnesses.
No.
No, my lord,
Not
it is
filed.
an order
Not
of the High Court. Order of the High Court which recorded that the seizure witnesses have not identified the accused persons. Page 85, my lord.
This is after the trial commenced, this order also.
Yes,
What is the
my
date of
lord.
this
After
order?
the trial commenced, my lord. And
This is 3rd December 24.
yes, my lord. And here, the last witness was examined on the, my lord, the last witness was on 23rd August 2023. That was the last, more than 2 years. Now, may I take lordship to
But he
page?
doesn't say anything about whether he recognized you or not.
No, he didn't, because page
Show us
15.
the seizure witnesses
Lordship,
depositions.
Lordship, that may not be there, Lordship. That
The
may not be.
depositions
The-
produced then.
I am
Who are
submitting
the seizure witnesses? PWs?
PWs 1, 2, 3, Lordship.
1, 2 and 3.
Yeah, Lordship, PW 4 and 5.
Depositions of
No, 2
PWs
and 3,
1,
not 1 and 1, but 1 is the expert. 1 is the, my lord, the expert.
Who are these
It's,
seizure
2 and
witnesses?
3.
Mr. Sarkar? 2 and 3. Very good.
Yeah, 2 and 3 have stated
That
that
produce the other
The
materials.
depositions of PWs 2 and 3, comma, the seizure witnesses shall be produced on the next date of hearing.
May
By
I?
the next date.
Lordship.
On 6th January.
Lordship, may I just submit my instruction? Lordship.
Produce that. You can't make statements in the counter without responsibility like this. How do you make a statement of that fraud and then say that I don't?
Lordship, I'll maybe then give me a liberty. I've just seen this one, Lordship. I'll just put a better affidavit, Lordship. Record also. Oblige, Lordship.
Please, Your Lordship. Lordship, in this matter, there are 2 judgments I have able to discover. That is the one of Calcutta High Court and of Delhi High Court, where this judgment as it is has been referred upon.
Which judgment?
Kalu judgment, which I filed on the last date of hearing, my lord had directed the state to find out whether any further directions are issued. But these are the only directions.
I see, these are.
These are the, and they have been referred in various judgments of Delhi High Court and Calcutta High Court. Now, as far as this Lordship may, I have said certain points, Your Lordship. This recovery is of not of any other drug, but of fentanyl syrup, which is not necessarily a person might know that it is a scheduled drug.
Yes, Counsel.
No CDR connectivity, Your Lordship.
Well, I beg to appear.
Yes, Ms. Bhatt.
Mail.
As we have checked up the Calcutta High Court judgment that my colleague gave, that's an interim order, but the final order is a cursory order which reaffirms those
So
directions.
you are required to videograph the seizure,
As per this judgment, we are, my lords, and
but you're not doing it.
in this case, it was not done. The High Court asked us to file a report, and we filed a report indicating that on the day of the seizure, in this case, there was a cyclone, and therefore the cameras got wet. If your lordships will permit me to show from page
That
4.
is neither here nor there. Did they not have mobile phones?
My lords, that is a contention that is raised before the High Court also, but
Very well, then we'll give him the benefit of that.
and as before your lordships is A1,
Yes.
the trial, otherwise the charges have been framed on 18th of September 25. There are 10 witnesses, my lords.
Very good. And 10 witnesses. Are you at least now instructing your NCB officials to see that seizures are videographed?
My lords, now there is a provision in the BNS also, so that is being done,
They
my
are
lords.
doing it?
Yes, my lords. I'm sorry, witnesses are 13. I'm sorry, my lords.
13. we have granted the appellant is aggrieved by the denial of regular bail by the High Court of Calcutta, Circuit Bench at Jalpaiguri in CRN video order dated 21/5/2025, asked in CRN NDPS number 4 of 25. The matter arises under the Narcotic Drugs and Psychotropic Substances Act. The appellant was named as an accused based on the statement made by the co-accused named him, or he himself took you to that Zakir Hussain?
So, Your Lordship,
I see.
I was taken, they
You
say I
were
took
taken. Very well, don't say that.
disclosure statement.
Appellant is alleged to have been involved in the trafficking of penicillin cough syrup, containing the prohibited, containing codeine phosphate, which would come within the ambit of the provisions of the Act of 1985. However, we are informed that the seizure of the contraband, this, 16,549 bottles of penicillin cough syrup was effected without videographing such seizure. This was not in keeping with the directions of the Calcutta High Court. In its order dated 22/6/2022, asked in CRN within brackets NDPS 492 and 493 of 2022, titled Kalu SK alias Puran KURA versus State. Which require that such video recording should be made of the entire procedure in relation to the seizure of narcotics, and in the event of failure, reasons therefore should be specifically recorded in the investigation record, and more particularly, contemporaneous documents, including seizure/inventory list. Admittedly, there was failure on the part of the authorities in abiding by this mandate in the case on hand, though an excuse has been offered that there was a cyclone at the relevant time, affecting, you had cameras with you, is it?
Cameras got wet is what we have said in the report.
Affecting the cameras which were available with the officials.
I'm sorry.
There is no explanation as to why such recording was not done on the mobile phones, which would have been available with the officials. In any event, we find that the charges have already been framed against the accused, and we are informed that 13 witnesses have been listed by the prosecution. It is therefore clear that the trial would not conclude in the near future. In these circumstances, we are of the opinion that the appellant would be entitled relief at this stage. The appeal is accordingly allowed, setting aside the other. So the appellant shall be released on the appropriate terms and conditions to be fixed by the trial.
Right.
Would your lordships consider saying that this is for the purpose of the bail, my lords, because the trial should not?
Every order that we pass says so.
I'm grateful, my lords.
It's by default, it's there in every order.
I'm very grateful, my lords. Lordship may consider adding one more date of Calcutta High Court. The final order was 11th of November 22. My lord said the
Order
order's date.
was on 11th November 2023.
2022 itself, my lords.
2022 on the same lines.
Please, my lords. Grateful.
Please, minutes. Your Lordship's last order had asked the state of Tamil Nadu to substantiate the fact that 10 crores came to me.
Some additional affidavit was
Yes,
filed.
Yes, my lords. The state has not substantiated it.
I'm sorry,
It had-
my learned friend is not correct.
Just 1 minute, sir.
Yeah.
My lords, all that they have said is that my brother's wife, my father-in-law, my
What
mother-in-law,
properties?
together amounting to 40 lakhs.
No, 71
No.
lakhs.
No, the figure is 40 lakhs, 50,340.
Page 4.
Yes, paragraph 6,
Yeah, 40 lakhs, okay.
40 lakhs.
But
There-
A14,
may I clear-
A14,
The one statement that you made. in the-
A17, my lord, A17, confession of A17, my lord, it says.
It's a
page 14, my lord.
161 statement and A17 has got bail, my lords.
A17 has already been released.
Has already been released. May I hand over and the A17 bail order is not on record. May I just hand it over, my lord?
Lord, A17,
Yes.
my lord, this person ran away to Dubai.
I came back.
He returned.
When he
came
there was
back.
a NOC.
Caught him when he returned.
Caught him when he-
He was leaving.
No.
So why would he return?
Because
No,
because
because
my
wife
wife
was
was pregnant.
Wife came first, then he followed.
Well, he was aware that this case was looming large there in
Yes.
the horizon.
And my statement
So in
itself
spite
says,
of that, he came back.
my statement itself
Because
says, so, my lords, they've recorded my statement, they've sent
But
to the
that
High
is
Court.
material to show that this 10
My
crores
lord,
was.
my lord,
Nothing.
A17, my lord, in his confession,
Yes.
at page.
Confession, unless there's recovery pursuant to that, the confession won't.
Not my confession.
No.
It's a co-accused.
His own confession also says,
Even if he confessed,
yes,
unless you have a recovery, you can't rely on that.
And my.
What did you recover pursuant to that?
pursuant to it, I did not.
No, did you follow up on what he said?
No,
when
because he says-
placed that amount in another particular account
No.
which he had made?
No.
No, he says at page 51,
Page?
51, my lord, in the
51 of his additional document,
additional counter.
Yes.
additional counter.
Yesterday's edition, page 51.
The transaction titled Nagarika, he was the one who was looking after all the accounts. Was sent to the shop run.
He asked you for specific information with regard to this 10 crores. If you
Nothing.
have something concrete,
No, no, he admits that he received.
admitting. we already
I
told
also
you,
say that I
27
gave it
evidence
back.
that works
I
in a
gave it back
particular
to him.
manner.
No, it's not the question.
There's no
Now,
question of you saying that he made a confession to me after I beat him black and blue. Therefore, it has to be believed.
Yeah, I understand. my lord.
That, where's the,
I
where is the
understand.
recovery then?
The only thing is they have siphoned off and they have sent it to
Where
buy.
is the
That's what he
recovery?
says. That's what he says.
What?
No.
Some of it has to go somewhere, is it not?
Yes, but it has got the Dubai, my lord. Page 40.
10 crores you said was diverted to his family members.
No,
What did he say?
No,
I didn't say anything.
That he has not said.
And at page 45, just for my learned friend's benefit, as I faced difficulty in deciding where to stash the 10 crores given to me, Rajshekhar, that is the kingpin, said he would take it to the grand apartment where his friend was residing and he kept it there. So the 10 crores didn't even come to me.
Lord, only one thing, my lord. Let
My-
him surrender.
Well, she's an accused too. She's not
She's
before
not
us.
an accused.
She's not before us. We can't
All right.
pass a direction against
All
someone.
right,
who's
all
not
right. At least
before us.
his passport. my lord.
Absolutely.
You do not wish to go back to Dubai again.
Nowhere.
Very well.
Nowhere, my lords.
Very well. Surrender the passport.
No, at least that family property.
I have a
my
wife
lord,
and 2 children.
They should not alienate at least.
What properties?
I have said so in my.
Families, how do you pin it on
No,
him?
because from here.
Where is the basis for us to say that this amount went to them and that they used it for?
All
this
these
purchase?
properties were
All
documents.
ifs and buts orders will not pass. Unless you have a clear chain leading up to
Yes,
it.
your
You
lordship.
can't say that some family
No,
member,
I
his
understand, my lord.
second cousin shall not sell
No,
property.
no, your lordship.
What is that?
3, at page 3. The document, the properties which has been purchased are from 2022 to 2023.
40 lakhs
Where is the
overseas
link?
people.
You know, those people, they don't have money, my lord.
How do you know that they don't have money? What investigation have you done? Unless you're able to show that this person transferred this amount into this
My lord,
account.
it's a huge,
This account belongs
it's a
to this
huge
cousin.
scam, my lord, about
Wait, you don't have any evidence, nothing. You just want us to act on surmises and conjecture.
the time, my
Not
lord,
possible.
2,500.
Dealing with 36,000 crores. So 500 crores is a.
I know, my lord, it doesn't impress you a lot. So,
These days we're only dealing with scams, they're running into those kind of figures.
yes, that's true.
Yesterday the argument was, this is only 250 crores. So we have to take a liberal attitude,
I
if it
know.
is less than, I don't know, 2,500 crores maybe. These scams also are not on a low scale. They want to take care of some 100 generations after that.
I know.
So
The only thing, at least passport.
let him surrender his passport.
Isn't it?
The appellant, they granted, the appellant is aggrieved by the denial of regular bail by the High Court of Judicature at Madras, with a judgment and order dated 9/7/2025, passed in criminal OP number 12384 of 2025, in connection with FIR number 7. The appellant has been in custody since 28/3/23.
Please,
28/3/2023. What is the stage of the trial?
no, nothing.
Nothing else.
Investigation is going on because A9 is,
Investigation is still ongoing.
chief man is abroad.
It is an admitted fact that
NOC is pending.
appellant was apprehended at the Chennai airport.
Yes.
At the Chennai airport when he returned from Dubai on the basis of a lookout circular. So various allegations have been made against the appellant. It is for the prosecution to establish the same during the course of the trial. As matters stand, we find no grounds for any custodial interrogation of the appellant, who has been in prison since 28/3/2023. He is accordingly allowed setting aside the judgment and order dated so and so. The appellant shall be released on bail on appropriate terms and conditions to be fixed by the trial court. In addition thereto, the appellant shall also surrender his passport to the trial court and shall not leave the state of Tamil Nadu without the prior permission of the trial court.
Lord, only one small correction. A9, my lord, has been arrested at Abu Dhabi. Extradition proceedings are pending.
We don't want to say anything
Yeah.
about the other.
Yeah, all right. No, I said that he is not arrested.
The order may be out today, another time.
Bail orders are given priority. Even if I don't, she will.
Like this.
So,
No, he'll be home for Christmas, that's about.
yes,
He'll
Obliged.
be home for Christmas, that's.
Obliged.
It is what it is. So now it's an admitted position that there is no
there is
FSL
no
on.
FSL report.
Yes, I,
But without the FSL report, charges are framed.
no, so FSL reports, so we have the mobile FSL unit millets.
That is all right, but
Which is there in most of the
Ms.
cases. millets.
Swati, we have
I
found
know,
that is not final. because
understand,
we do all kinds of mistakes with that spot checking.
I understand millets.
The test identification kit or whatever you call it.
I must fairly submit millets in most of the cases. The FSL report comes later.
But
During-
not after framing of charges. At least after
There's
the
a-
charge sheet is filed, it's one thing. But
I-
here the charges are also
That
framed
issue is in
without.
fact, that issue is in fact pending before another.
That's with
bench.
regard to the charge sheet.
That's right, Millet, whether
Whether the
it.
charge sheet would be a proper charge sheet if you don't
Without
file
the-
it with the.
Yes, Millet.
That's at page 70, my lords. That
Millet,
is-
I can't, I understand that, so that's the fact, I cannot deny that. And so far as the spot testing is concerned, Millet, it has given a positive for mephedrone.
Mephedrone.
Yes, and he was found in conscious possession, Millet.
How much was there? 50 points.
Grams.
Just about the commercial.
50.2.
I'll not say anything more than that, Millet. I'll leave it to God, but I must place.
Was it there in a
facts.
container?
No,
It
Millet.
must have been.
Small-
It was in
Mephedrone,
a,
we are told is powder.
it was in a pouch.
It's in a pouch. So what was the weight of the pouch? Would it be? You don't know how much. It's 50.620 grams. So a pouch would perhaps be 0.620 grams.
I'm not on commercial quantity millets. I'm only.
You know, because you mentioned that in your FIR also. So we need to be conscious of that fact.
Millets, I am bound to place the correct facts in record. All that I'm submitting millets.
Trial is yet to begin.
Charges are framed. No, it has started millets.
Started now.
One witness.
One witness has been.
Out of 27.
Out of 27. even though he does not have any antecedent under the NDPS Act, there's one case.
There's one under 302.
302. Yeah, not under the
He
NDPS.
disclosed it.
Yes.
Yes, sir.
He
Base,
disclosed
yeah.
it.
God minutes.
Very. Leave granted. The appellant is aggrieved by the denial of regular bail by the High Court of Gujarat at Ahmedabad with a judgment and order dated 1/9/2025 passed in criminal miscellaneous application number 15238 of 2025 in connection with that crime under Swan Search. The state of Gujarat filed its counter affidavit. Yes. The appellant has been in prison since 18/1/2024, and the charge against him is in relation to the seizure of 50.620 grams of methadone. We may note that the commercial quantity prescribed under the Narcotic Drugs and Psychotropic Substances Act 1985 in relation to methadone is 50 grams. It is not clear as to whether the container in which the 50.620 grams of methadone was seized was weighed separately and whether the actual amount of seizure would qualify as being above the commercial quantity. That being one aspect of the matter, we are informed that the Forensic Science Laboratory's report is yet to be filed, though charges have already been framed. The trial is stated to have commenced, but only one out of the 27 listed witnesses has been examined. There is therefore no possibility of the trial concluding anytime in the near future. Given the aforementioned facts, we are of the opinion that the appellant would be entitled to grant of relief at this stage. The appeal is accordingly allowed, setting aside the interim judgment and order details. The appellant shall be released on bail on appropriate terms and conditions to be fixed by the special courts.
Item number 6, Miller's custody is 2 years, 8 months. Now, Miller's, the Lordships asked us to Miller's implead. Miller's, now the Miller's complainant has been impleaded. Now, the matter has been settled. Essentially,
State wanted to file a counter.
State has filed, Miller's, please see.
You've got 19 other FIRs.
Miller's, yes, I have played, Lordship, see page C, Miller's, I have explained, Miller's. In so many of them, Miller's, I have been
But you
acquitted.
seem to be settling as and when someone takes you to court.
No, it's not. No, it's not that. There are clear acquittals also, Miller's, and Miller's, State itself says in its counter.
19 other FIRs.
No, Miller's, 19, Miller's, out of 19, Lordship, see page C. See for a moment, Miller's.
Page C.
Yes.
What is there? Page C?
Miller's, I have
19 FIRs.
yes, Miller's, I have given the chart, Miller's.
Yes.
Lordship, see, Miller's, 1, 2, 3, Miller's, acquittal. Thereafter, Miller's, again, Miller's, 4 and 5, Miller's, closure report. Then Miller's, again acquittal. No, Miller's, I'm
5 says closure.
I'm sorry, Miller's 5 and then Miller's 7. Then Miller's
7 is an acquittal.
yes. Then Miller's 12.
Closed is 12.
Yes, Miller's. Then again Miller's 14.
Whatever wrongly mentioned means we don't know.
Yes.
Wrongly mentioned what? Your name is wrongly mentioned.
No, Miller's. Yes, Miller's. No, Miller's. This case, Miller's, I'm not there.
Case itself is wrongly mentioned.
No, Miller's. I'm not there in this case.
You are not there.
Yeah, I'm not there.
But they've given details of 19 FIRs.
Yes, but not
This also is
yes, but not the status, Miller's. They have given not the status, Miller's.
This one also is included in that list of 19.
Miller's,
the counter.
I'll check it, Miller's. Just. Yes, Miller's.
There?
It's there. Miller's.
435.
It's there, Miller's.
Yes.
It's there. But Miller's, they have simply reproduced Miller's. I have checked up Miller's, and after checking Miller's, I have prepared this Miller's. And Miller's, today Miller's, substantially Miller's, the civil suit which he has filed earlier in time, that has been Miller's, that has been withdrawn as compromised. Miller's, and in his counter itself, Miller's, the state is saying Miller's, all have been granted bail. Bail except
What
bail.
exactly is your case against him that he keeps doing it again and again? This IPAs and transfer of the land.
That's the case, Your Lordship.
That's the regular modus. You are for the complainant.
No,
You are for the
yes,
complainant.
yes.
You settled with him now.
Yes, Lordship.
And what do you say?
We have got back to land, Lordship. we have got back the land, civil suit has been withdrawn, we had filed civil suit, and then 7 months later, my
You
husband.
succeeded because you held a gun to his head. There
Yes.
are others who are waiting in the queue. So should we take it that each case will come up and then
Lordship may not take it,
you will settle with each of
the
them?
length
and
of
then-
custody, please see.
But how is it possible that you would have this many cases? We can understand a civil dispute being one.
May I say with respect?
But if you do this is your regular modus operandi, then what are we
May I
to do?
say with respect, Lordships with vast experience are aware. Lordship may say how out of this 19 at least 10 and 11 there are either closure or acquittal. So 8 and 9 cases are.
Closure is obviously because you settled with them.
No, it's not. No, it's not that. It's not that. It's not that. It's one particular case wherein certain things land has been given. I'm certain amount which I need to pay, and they are saying the moment I'll come out, I'll pay them. It's not a quashing
Even this case, even if it goes to trial, he's going to turn hostile.
Yes, Lord. We have got no objection. We have filed affidavit also.
So this was also.
Anyhow, it's only a bail.
Yes, I'm not taking quashing, not at all.
Bail granted. The appellant is aggrieved by the denial of regular bail by the High Court of Punjab and Haryana at Chandigarh. In connection with FIR number so. The complainant was.
Yes, Milords. Yes, Milords.
Have you already-
Yes, Lord.
Yes.
The complainant was brought on record as respond number 2.
Plus 2 to 4, Milords.
2 to 4.
The complainants who were brought on record as.
By IA number 29629.
2 to 4. Have you filed an affidavit also?
Yes, Lord.
Have filed an
The
affidavit
page number 9 and 10.
stating that their issues with the appellant have been settled and the civil suit filed by them against him has also been withdrawn.
Yes, Lord.
Has also been withdrawn. Though the state of Haryana has filed a counter affidavit furnishing the details of as many as 19 other FIRs which have been registered against the appellant in similar offences.
Similar.
By and large.
By and large.
I must
By and large, similar kind of offense in relation to by and large, in relation to by and large, similar kind of offences, we are of the opinion of the settlement by and between the appellant and the complainants, the appellant these terms and conditions to be fixed by the judge.
Obliged.
Grateful.
Very good.
Lot of things will happen. Bails we are granting today, but somebody will have to put a stop to it.
Well, it's maybe in some other maximum.
Or not in yours. Yours is also penciled in.
Petitioners are in custody for
It's
more.
only 255 bottles. It can't qualify as 1 kg. How much codeine would be there in each bottle?
About-
You're still not getting that information.
About 180 mg to 200 mg per 100 ml.
Per 100 ml, there'll be
180 mg or
180 mg would be there. And you need 1 kg for
1 kg.
So how much would be there in 255? Have you done the math?
It would be about 600, 700 grams.
Well, we granted. The appellant is aggrieved by the denial of regular bail by the High Court at Calcutta. With a judgment and order dated 8/7/2025. The CRM within like was number 580 of 2025. The appellant has been dismissed since 8/10/2024, and the case against him involves the seizure of 255 bottles of penicillin. The quantity said since psychotropic substances that will be defined, which substrate is which the situation affected by the authorities would not bring it within.
Well, that issue whether you need to calculate the entire quantity of the
0.25, there's a government notification also.
No, that issue in fact is pending for a larger bench whether you need to take so.
the issue as to whether the seizure would qualify as one pertaining to a commercial quantity is therefore open to question. What's the issue? It is also openness. It's not open to question, it's also open. In these circumstances, charges have not been framed.
They have been framed. In 22nd May, 2 witnesses have been examined.
The charge sheet has already been filed on 4th April. Don't say already. The charge sheet has been filed on 4th April 2025, and we are informed that the charges have been framed. The prosecution has listed 11 witnesses. 11. And the trial is yet to commence?
No.
Well, that's one has already been.
My instructions are 2 have been examined.
These said 11 witnesses has been examined. There is therefore no possibility of the trial concluding anytime in the near future. In these circumstances, we are of the opinion that the appellant would be entitled to grant the appeal. The appeal is accordingly allowed, setting aside the interim judgment. The appellant shall be released on bail on appropriate terms and conditions to be fixed by the special judge.
Like your lordship.
Please, my lords. As reply has been filed. May I make submissions? May I make submission, my lords?
Yes, go ahead.
My lord, sorry, apologize. In the last matter, may I give physical opinions?
Yes.
My lords, I would start by saying that my client has been completely innocent and has been falsely
We are not
implicated.
deciding that.
My lords, why I'm
We
saying
are not going to give you a stamp of innocence so that the trial stands settled at this stage.
my lords, one Narendra Shah has been caught with 195 kg commercial quantity.
Yes.
He says that Happy Singh,
But the truck belongs to you.
The truck belongs to.
that truck belongs to a company, and they say that I'm a caretaker. I am a caretaker of that company.
Caretaker.
Caretaker.
It's a company.
It's a family.
What kind
It's
of
a family enterprise. So it's
family entity?
his brother owns the
Oh,
company.
is it an incorporated body? Is it
It's a proprietorship.
firm?
It is a proprietorship. It is a proprietorship.
Obviously yours then.
It is a proprietorship.
You can't call yourself a caretaker then. You're a proprietor.
My lords, Happy Singh has been said that he took the entire truck to the place Bhubaneswar, and from there he bought the truck. He has been granted bail, my lords.
Who has been granted here?
Happy Singh has been granted bail.
Narendra Shah is inside?
Narendra Shah is inside. Nothing has been recovered from the truck. my
The
lords.
truck belongs to you. You have to explain as to why your truck is running around with 195 kgs of ganja.
My lords, nothing has been recovered from the truck.
What do you mean? Where was this ganja? It was in the truck.
No, my lords. It was at the home of Narendra Shah.
It was not in the truck.
It was not in the truck.
my lord.
Later on, it emerged that the truck was used to transport the ganja, and then it was
Who told you that the truck was used?
the main.
Narendra Shah told you.
main accused.
Not Narendra Shah. Happy Singh told them, and Happy Singh is on bail.
What, did you find any document to show that the truck went through any toll gate with this contraband just before the seizure or something like that?
Not yet. Not yet.
And if you don't have that, how do you link it?
But at the moment, there's only the disclosure statement, but that is a matter for the trial court to.
No, but you at least need to have something to show us. I thought the contraband was in the
No,
truck.
it was not in the.
Oh, it was not in the truck.
Please, my lords.
Then he's entitled to grant of relief then.
But Millard's, the
With
application was
the,
withdrawn in
with
the
the same
first
trend that has been going on since the morning, I don't know which case will have to put a stop to it, but obviously this case also continues with the same trend.
Great, my lords.
Some other day maybe we'll have a better case.
You
to
don't
argue.
have anything at all. You filed a counter also.
Yes, it's there. In the
In
record.
your counter, you don't say anything as to what you found with regard to the truck being linked to this.
It's not there. It's not there.
It's the first thing you would investigate, is it not?
Well, it's
How do you put him in prison and then do nothing about how to link up the truck with the seizure inside the house?
sometimes it's a trouble on our part with the replies. So,
Your investigation, if it's this haphazard, then there's nothing we can do.
My lords, the custody is 1 year, 5 months.
Be granted. The appellant is agreed by the denial of regular bill by the High Court of Punjab and Haryana. The judgment and final order dated 11/9/2025 passed in CRMN number 49834 of 2025. The appellant has been in prison since 21/7/2024. The allegation against him is that his truck was used by one Narendra Shah for transporting 195 kgs, 810 grams of ganja. Full stop. Admittedly, this contraband was seized from the house of Narendra Shah.
House of Narendra.
House of Narendra Shah. And he stated that the transport, he stated that he had transported the same by using the truck belonging to the appellant from
Odisha.
to Faridabad.
Odisha to Faridabad.
From Orissa to Faridabad. From Orissa to Faridabad. However, we find that though the state of Haryana has filed a counter affidavit, there is no mention as to how the prosecution seeks to link the appellant's truck with the transport of the contraband from Orissa to Faridabad. There is no mention of any investigation having been done in that regard, which would clinchingly indicate that the appellant's truck was, in fact, used for the transport. We are of the opinion that the appellant would be entitled to bail at this stage. What is the stage? 7 out of
7 out of
7 out of 36.
28.
Entitled to bail, as only 7 out of the 28 listed witnesses have been examined till date. The appeal is accordingly allowed, setting aside this. The appellant shall be requested on networks, terms and conditions of the discussion.
Grateful months.
Well, this is in petition praying for grant of regular bail minutes. My bail application before the High Court by an order of October. Minutes. I have been the allegations in the FIR is that I have committed offence in the section 3 and 4 of Maharashtra Control of Organized Crime Act for running an organized crime syndicate. Minutes. The gang, as per the allegations in the FIR, is led by one Mohan Singh.
Who is your brother-in-law?
My brother-in-law, minutes, and other family members of Mohan Singh are there.
Brother-in-law as in wife's brother or
sister's husband. Sister's husband.
Right.
Minutes. Now, there are two issues in this. First, my involvement in any of the FIR which has been reflected in the proposal and the approval and subsequent FIR. No roll minutes, no witness as charge sheet has already been filed minutes.
You are supposed to have helped in the disposal of the ill-gotten wealth by that Mohan and his
minutes.
syndicate.
There are two allegations which have been alleged against me.
One of his cars is sold and you
yes,
get the money.
These are the
right
two.
now.
Yes, these are all.
And his mother's plot is sold to your mother.
Only one. This is a factual thing. There is a legal argument also. Minutes. First is that Mohan Singh's mother has sold a plot of land to my mother, Geeta Devi. This is one allegation. But this is not a sale. It's a power of attorney. No registered deed is there. Minutes. First of all. Second, minutes, there is allegation that Mohan Singh sold a car to a property dealer for a sum of 7 lakh something. And out of that, 2,90,000 has been transferred into my bank account. So this is a car loan. My defense is that I have taken car dealer has taken a friendly loan from me, which he has returned to me. This is the defense I have put in my minutes defense before the investigating officer.
The person who bought the car.
Yes, well, the car dealer has taken a friendly loan from me, which he returned to me in my bank account. 2,90,000.
It's a bit a little suspect.
Well, this is the defense I have put before that. Before the trial court, I have to put. What should I say? Second, minutes apart from.
Joint investigation.
Completely agree. Minutes. One last argument, which is very important. One second, minutes. No, minutes. One important.
I've noticed.
Minutes. Yes. Minutes. Minutes. I have been a PO. I was arrested on 11th of June. Minutes. There is a technical problem in this FIR. Section 3 and 4 of Makoka cannot be registered alone. There is no substantive. No, minutes. May I say this? Minutes. Only one argument. Minutes, please. I just request, minutes. Let me complete this sentence.
The very fact that you were absconding.
Minutes. That doesn't matter. There is no case. Minutes. May I say this?
For you to establish there.
Minutes. Only one thing. Minutes. May I say this? Minutes. Please listen to me. One last sentence. Minutes. There is a judgment of this court. Minutes. 2015. State of Maharashtra versus Shivaji. I have the copy, minutes.
Which states that 3 and 4 have to be supported by
substantive IPC offence.
That you raise in your court
Minutes, it
petition.
can,
That
minutes,
is- that
it's
can't
my-
be a ground for
minutes,
transfer.
minutes, my personal liberty is getting infringed. There is no FIR.
You're absconding and then you're caught.
No, minutes. If there is
174A.
if there is a technical legal problem,
Anyhow.
that Makoka cannot stand alone, minutes.
The trend stops here.
Minutes, may I say this?
We will
Minutes,
dismiss your matter.
minutes. Otherwise, also there is no witness against me.
We find no good ground and reason to interfere with the impure judgment passed by the High Court.
I do.
Accordingly dismissed.
Please, my lords. My lords had on the last occasion asked to clarify with regard to the discrepancy.
Yes.
Lords, we filed an affidavit.
That affidavit. Got a copy of the affidavit?
I have received.
So he took the signature of his father on this.
No, my lords.
No, there is no
Father, there is signature of the father.
Signature of the father is there.
Is there? We
Yeah, it
filed.
seems my lord.
The copy
Lords,
is there.
page
which
9.
Has been filed.
Yes, my lords.
So you have Radhesham signing there.
So he basically was taken back
So he
home.
took him to the hospital?
No. After being injured, he was taken home by a particular person.
Yes.
Seeing his condition, he was being taken to the hospital by the wife and the son. While they were on the way, he vomited blood.
Right.
So that complaint that the person deceased had written was taken by the son and handed over to
No,
the
where was this written down? In the car?
No.
Or at the hospital?
My lords, no, they had not reached the
At the
hospital by then. While
It
going,
doesn't look like it's been written in a moving vehicle. So,
my lords,
so they
because he
stopped on the
no,
way
but
and then
he,
stopped, my lord.
any which way was taken home. While he was taken home and then thereafter he was being taken from the home to the hospital, in the way this was handed over. So my lords, though this is
on the way it was handed over while he was in the car.
while he was in the car, while they were taking him to the hospital,
So they stopped at the police station and this is.
and the son handed it over. They handed it over to the ASI.
Why would the police officer who received it not go out and look at him?
My lords, because the son just came, he had vomited blood. He came.
No, he would have said that he's sitting outside in the car. So do you have a?
My lords, his health was deteriorating, so he immediately.
Even then, if the son came in, gave this,
My
and
lords,
said that my father is in the car and taking him to the hospital,
my lords,
normal human conduct, not even a police officer. Anybody would go out and look, is it not?
my lords,
We have an accident on the road, people are busy taking pictures and videos and whatnot.
my lords,
They stop the vehicle and do that.
my lords.
It's very ghoulish on their part, but that is how morbid we have become. So it's hardly believable that your police officer would not have gone out and seen that, yes, the person is in the car. So you don't have any such person who has witnessed it.
My lords,
The whole difficulty is this very document becomes a little suspicious. If
but my lords,
Complainant himself.
my lords, it has come out in the statement of the son itself that he had gotten down of the car, given it to the ASI, came back and had left for the hospital. If my lords may just have.
They left for local hospital, my lord, but they never visited there. And even the wife said that she has handed over this.
And if you see the handwriting, this was obviously not written by Radhesham, because Radhesham's signature is a little wobbly.
My lords, I
Whereas the
understand.
complaint itself is very well structured, very closely written,
There is
My lords,
obviously not in a moving vehicle.
my lords, this,
So,
my lords,
how do we
cannot.
act upon this?
My lords, the point is that this
Where
would
you
have been
file your full-fledged counter.
very well, my lords.
even the complainant has admitted that
We've
it
not
was written by a T vendor.
We've not issued.
Notice. Yeah, notice issued.
Notice has been issued, my lords.
Issued?
Yes, my lord, notice issued.
Yes, issued. Notice. Learn counsel for the state of Rajasthan takes time to file a counter on minutes of the matter. Mention this before the affidavit explaining the contradiction, comma, recorded by this court in its order dated 20/11/2015, comma, the statement there. Then you say needful usual order after that, and then list on 20th January 20.
Very well, deeply obliged, my lords.
Your worship, for cancellation of bail granted to the respondent.
The other matter seems to have gone before.
Yes, madam.
Yes, Your Lordship. The notice has been issued yesterday, Your Lordship.
Appear for the state on
Notice
enhanced.
was issued.
Yes.
I'm not able to find anything on this.
Your Lordship, I have the details.
You have the order?
Yes, I don't have the order. It has not been uploaded, but
That's the whole point.
I have
I also checked online and I couldn't find any order.
I have the status, Your Lordship.
My lords, I appear on behalf of.
Notice has
state.
been issued in
Yes,
the-
my lords. Yes.
When will tag
Yes,
it?
yes.
Notice entitled 673 criminals, diary number 6703 of 2025. Title Suresh Kumar versus Fox.
325.
Number 12.
Right. Lordship, this is an SLP arising out of refusal to grant regular bail. Before I submit on the merits, 5 factors Lordship will kindly keep it in mind. I am in custody since 9th of August 2024, that is 1 year, 4 months. Charge sheet has been filed in January 2025. Trial is still at the stage of framing charges. There are 85 listed witnesses, and I have absolutely no criminal antecedents. Now, these are 5 factors which Lordship may keep in mind. Now, on the merits of the case, I am a licensed manufacturer.
What are the drugs and cosmetics?
As well as narcotics control.
Where is that?
That is where it has gone wrong. P7. Kindly come to P7. Oh, I will just tell Lorships. P7 is at page 41. This is where the High Court has gone wrong. This is
41.
Page 41, P7.
Yes.
Government of India, Ministry of Finance, Central Bureau of Narcotics. To Nakor Pharma Private Limited, subject issue of provisional CBN registration. And then please come to page 42. Please refer to application dated so-and-so, which request has been made for issue of CBN registration. It is informed that we have issued provisional CBN registration number to your firm so-and-so under the category manufacture and preparations of psychotropic substances, and a number is so-and-so. The provisional CBN registration number issued to your firm.
Don't they mention what product?
Yes, that is where it is. The provisional CBN registration number issued to your firm is provisional in nature and shall be valid for a period of 1 year. Following substances have been registered in your provisional CBN. That is where the High Court has gone wrong.
No, but even if you have a license to manufacture it,
yes,
you're diverting it elsewhere.
That is,
then they're entitled to take action against you. The seizure is some 94 lakh, 19,000.
I appreciate what is
police have seized 94 lakh, 19,000 tramadol tablets.
I appreciate what is. Let me respond to that. That is, I'm sure Lordship is reading what the High Court has observed. Now, that is not even the.
You're exporting it to Africa.
That is what. That is. May I just place it? Even that is not the.
Africans are bringing it here and you are sending it to Africa.
No. What? May I just clarify that issue? That is not even the.
In the other case, we found that some African is inside prison because he's supposed to have brought something. So we are returning the favor, is it?
No, that is. The question is this, Lorships. That is not even the prosecution case. Actually, after I read the High Court's observations, I actually saw what is the prosecution case against.
No advance notice? State Council?
Yes, we did.
One is there? Anyone online? No? Turnable on 3rd February. So it shall be affected by all these.
I'm very grateful.
Please, Your Lordship. I am against the dismissal of my suspension of sentence application, Your Lordship, by the High Court. Been convicted for 409-420 I have filed my appeal, Your Lordship. I have been convicted for section 420, 3 years, and 409, 10 years. That there cannot be simultaneous conviction. Rest aside on argument, leaving the arguments on.
Sorry, what was that?
I have been convicted for section 420 and 409, Your Lordship. Today there is a judgment by this Honorable Court, Delhi Race Club, that 409 and 420 cannot go together. There is my conviction for 409 is 10 years, 420 is 3 years. I am only an employee. It is admitted.
It was only 420 and 34?
No, 420 and 120B 3 years, Your Lordship, and 409 and 409 120B is 10 years. High Court today is hearing appeals of 2002 to 2005. My appeal is filed in 2025. The trial court judgment is of 21st of August. The co-accused who's convicted me, his sentence has been suspended.
Prior to his posting, all these investments took place.
Please, Your Lordship. That's also the case. The witness.
Whereas you've been working since 16 January
2017, I was transferred to this branch, but the PW1, who has not, the only witness, along with PW9, who has not turned hostile, says she invested in 2012.
I will give you a short date.
Please.
Issue notice, returnable 15 January.
Can I serve the standing counsel?
Counsel for the petitioner is permitted to take service of notice upon the when it's standing of the designated counsel for the state of Madhya Pradesh.
I'm grateful. Grateful.
Yes. Similar matters dismissed.
My lord, may please see, my lord, there is a question of law involved.
Several
But there are few other matters.
Not in 810 days in the filing of the special.
My lord, there is another batch of petitions.
Coupled with a further delay of 66 days in its refiling. That part, other special leave petitions filed against the very same impugned order of the judgment have already been dismissed by this court. Therefore, find no grounds made out to either condone the delay or entertain the special leave petition on merits. The condone delay petition and in consequence the special leave petition are dismissed.
Item number 15.
Lordship.
Yes.
If I may, in a minute, just give the overview of it, Lordship. Lordship, I file a suit in which I take the plea of passing off and infringement.
You say that the finding is that it's only an infringement.
Which is why I wish to point the error. I take that plea, the trial court absolutely considers that. The High Court has heard. Yes, please come. No, so Lordship may just come for a minute. My plaint, of course, starts at 53.
Yes.
And if Lordship will be pleased to come to 56 for a minute.
What is your prayer?
I'll come to
just mention something in the body of the plaint, but don't reflect it in your prayer. It's not a tool for passing off.
Lordship, 76 for a moment, just to see the body. At 76, I'm specifically raising the plea.
76? Yes, passing off.
Passing off. That the plaintiff number 1, Vaidya Rishi Laboratories, on account of being the first and prior user. I'm from 1970 and registered proprietor of the mark Vaidya Rishi in various classes, and due to its long and continuous use by the plaintiff, have acquired reputation and distinctiveness in the trademark, which has been in use for more than 50 years. Is Lordship with me?
We are on page 82, prayer B, passing off.
I'm so grateful. I was about to come. I'm so deeply obliged.
Then why is it that the High Court proceeds on the assumption that it's only an...
I am sorry, but Lordship, I can't answer that, but that's the error that I'm challenging. And the trial court has in the judgment, at page 147 to page 149, considered passing off, Lordships. And Lordship, I must point out also on the conduct, one sentence. In the written statement before the trial court, they admit that they are dealing with Ayurvedic products. In the High Court, their stand changes that we are not dealing with class 5, which is pharmaceutical and Ayurvedic products.
Issue notice.
Your Honor,
we have Lordship.
I appear for the caveat in this matter.
There's no caveat, or there is a caveat?
Your Honor, just have para 14
But
of
if it's a suit for passing off, obviously the High Court...
They submit before the Honorable High Court that this is a plain suit of infringement. They got the statement, para 14. I don't know why they are not reading it.
No, I'll answer that also.
It's absolutely wrong.
No, but the suit...
In para 14.
Yes, Lordship.
In para 14, it is categorized. No, High Court has put a specific question to them. And they have answered it. The counsel appearing on behalf of the petitioner herein. Para 14, Your Honor.
Lordship, I'll satisfy Lordship's conscience. Please come to page 17. I'll assist Lordship.
Para 15, fourth line from bottom. He submits that the case is plainly one of infringement as the respondent has priority of registration as well as of use of Vaidrishi marks over the
It's contrary to what the plaintiff itself
Exactly.
states.
Your Honor, the passive.
Issue notice returnable on 28th January. Mr. So-and-so takes notice.
Would it be possible, Lordship, just a couple of days ahead or before Lordship, the 28th, maybe in the first week of February, if it's not?
Then, fourth,
Would Lordship,
4th February.
4th February, I'm so obliged. And Lordship, we had of course prayed for a stay, but I with your hands. Because they are using the product on it.
Earlier I was using it, you got a stay on me. I already suffered.
Because I had originally injunction.
Let the counter come
No,
there.
I'll show.
I'm great. I'm deeply obliged, Lordships.
A short accommodation, my lords, as the main counsel is not well, my lords.
And you've also filed a condone delay petition without indicating what is the length of delay in the filing. Nowhere in the SLP limitation report, there's no office report, so we don't know what the delay is.
My lords, I'll seek instructions to that regard as well.
I don't know this. It's strange. This practice which is being followed here is beyond comprehension. It defies common sense. Without your knowing what is the length of delay that you need to explain, how will you explain it?
My lords, actually the main counsel is.
If you leave it blank and it is for the registry to fill in the number of days of delay, then how do you explain that delay?
My lords, I'll keep that.
There are judgments also which say that it should be done on day-to-day basis. You have judgments to the contrary also. But how do you explain delay without even knowing what is the length of delay that you are explaining?
Please, my lords, I'll keep.
Perhaps you should pass a judicial order also that the registry should not be doing this job for you. Whatever other equations you have with the registry, let this not be one of them.
Please, my lords.
And counsel seeks an adjournment on the ground of personal difficulty of the arguing counsel. We find that condone delay petition has been filed, but the number of days delay has not been indicated either in the petition or in the office report on limitation. We may also point out that it is for the learned counsel who files such an application to fill in the number of days delay and not for the registry of this court to undertake that exercise. As the applicant in the condonation, in the delay condonation application to explain the length of delay with reasons therefore, and obviously he or she would not be in a position to do that without knowing exactly how many days delay has been quantified in that regard. The registry shall take note of this aspect. Copy of this order shall be placed before the Registrar Judicial of this court.
I'm grateful, my lords.
List on 9th March.
Lordship, item 17, Lordship, as per the infringing Lordship order, Lordship already issued notice, Lordship.
What is the other matter which
Lordship, this is the order, Lordship.
Yes, it's.
You trying to tag with this?
Notice and tagged with.
SLP civil number, Lordship.
Civil diary number
37757
of 2025. Delay has been condoned.
It has been condoned, Lordship. Now it has been turning SLP number, Lordship.
Number
is civil, yes, Lordship. 36322.
36322
of
36331.
2005.
This there is no delay.
Please, Lordship.
What I have to do?
Now all non-teaching post aspirants age relaxation is to be given.
That's what I'm appearing for the state, Lords.
Single judge has done that. 20 lakhs, 21 lakhs.
And this will upset the teacher's examination also, which has concluded.
Aspirants would be there with this.
21 lakhs.
21 lakhs.
26 lakhs. 26 lakhs. In 2016 selection process.
But did you not bring to the notice of the learned judge seems to misunderstand Arunima?
But on the very first day, no,
Lord High.
nothing.
Unless below
This
is published, tainted or untainted. Scores clear.
This is not untainted.
Arunima Paul was also a candidate who had not been selected.
No, yes, that's true.
Therefore, we said that the division bench did not grant her relief.
But that was,
whereas the High Court now records that Arunima Paul was granted relief. What is
no, Arunima Paul did not, High Court did not record that. Arunima Paul
was what Arunima Paul. Though it has been asserted by the respondents that a similar rule was under challenge.
Yes.
But the petitioner stressed in Arunima Paul's matter,
233.
in the said judgment, it is seen that the division bench has specifically observed in more than one place that the recruitment rules are not, but they don't, she doesn't understand what Arunima Paul said.
That's right.
Paul was not given
that
the
is,
They had rejected.
Another one
was respect of the teacher.
Kindly
This is teacher. This is not teachers.
This is non-teaching post.
This is non-teaching post.
High Court can't no kind of age relaxation across the board like that.
No, my lord was
judgment of saying, my lord, after your lord's passing of the last order, that all issues will be decided. Now, my lord, innovative things are going on. Every matter, every day, 15 matters, going to the court, leave, granted, next day, order, nothing. No, we are not in a position to do it anything now.
My lord's order.
I will be another 4 SLPs are in queue. It has not been
These are persons who have not even gone to court.
No.
Yes.
Understand if High Court limits it to those who went before all untainted candidates. If they participated in that selection, all of them to be given age
relaxation. This is a long perception by the recruitment authorities.
10 years age relaxation.
And after this order,
the order.
Lord High Court cannot modify the direction of this court under Article 142.
Kindly after this
staying this order.
Yes, after this order, he teachers.
The staying means the recruitment is stayed. I don't mind.
9-10.
No, you'll be holding an exam for this also.
No, yes, they have not fixed any date yet.
Not yet.
9 class C.
That's for teachers. But there is no time limit fixed by this court for group C and group D.
Lord, the teachers is concluded. Teachers selection is concluded.
Month of January or February, so far CD is concluded because there is no time of your lords.
Unteaching post we have not touched it.
That's right.
I will ask not the least.
January or February, we will wait.
No, but the learned judge is taking up the matter again.
Yes,
kind of the operation of the order.
Mainstream order. Let them go and explain.
No. What I will explain.
The order is it?
Yes.
No.
What has happened? I tell you, lords, one lawyer has come. My lord, this is the urgency. Leave granted.
Because of the last.
Then on the second day,
were you not heard?
Yes.
We have heard, but no affidavit. Nothing.
Online application last.
Nothing.
Because of their last declaration.
Nothing. We have heard. It's not that way. But is it the way to hear the matter of a repetition? But in this matter, Calcutta High Court is going, crossing all everything.
May I just.
One lawyer is going, kindly grant me leave.
No, this is
and grant me leave is granted on the next day, top of the list. No,
Arunima Paul, para 35.
Yes.
The learned judge, in fact, records contrary to what Arunima Paul says.
Arunima Paul.
Look at Arunima Paul's judgment, which has been placed on record.
Yes.
Where does the learned judge find that in Arunima Paul, untainted candidates were permitted to participate in the relaxation?
That's wrong. That's wrong.
Specifically said that untainted candidates were not selected or not entitled.
That's right.
My lord's clear order was that the untainted candidates should be allowed to.
Well, kindly
Then-
come 227.
Let him finish, no, it's not good.
No,
enough
yes, yes,
together.
please allow me. 227 and 220. First pillar, 227, last few lines. Lord, kindly place 220 in the middle.
This is our order. Why would you ask Arunima for DD?
DP, I am saying.
DP order.
DP.
DP. 227 is our order.
No. Division bench order, my lord. It starts from page 210.
210.
Yes, see? First, second, third, fourth, yes, middle in the middle. These two categories of candidates.
Where are you reading?
227, my lord.
Are you looking at the same?
Item 18, item 18, kindly
This is
take.
item 18 only. Oh, this is 40. Oh,
Item 18.
18. So matter is still pending before the High Court.
But
Because the High Court is still seized of the matter, we will state that these directions shall remain in abeyance. Let them file their counter
Yes.
affidavit. Let the learned judge hear the matter on merit.
And that best
And then take a call.
yes,
That's the best course.
yes, I have.
Because one city High Court is still seized of the matter, which is not proper for us.
But unless the list is published, this will go on.
No.
I don't- yeah, direction was-
no scope to publish the list
No,
of
no,
untainted.
nothing. We are not saying
And
anything.
they are existing every day.
Every learned judge hears the matter on merits after hearing both sides on the strength of affidavits, not by way of just an oral hearing.
Very well.
without-
But my lord's order passed in Vivekpadiya, the latest order, wherein the court was absolutely clear that no tainted candidate should be slipped in.
We have
Unless
not.
they-
We
unless
have
they
not done it.
Court directed you publish.
No, this is in relation to non-teaching posts. We have not
Same.
touched upon non-teaching posts.
No, the
Any
main
of our-
judgment, main judgment remains.
My lord,
Main judgment.
Yes,
Therefore, my lord was very clear. No.
in case of non-teaching staff,
My lord was
we have
very-
published in the website, all tainted. Lord, what they are saying now?
Well,
Now,
I just,
Lord,
the latest order was
Lord,
that
claim is
main
going-
judgment,
Teaching posts.
No, no.
We have nothing.
no, main judgment will
Now-
prevail.
Main judgment
Yes.
will prevail.
That will not give
That's
us
right.
the learned
That
judge-
is to be raised before the High Court. We are not going to say anything.
Yes, yes.
my lord, claim is going to too much.
My lord.
What is a tainted? What is his house number?
High Court application.
What is a everyday innovative argument, innovative thinking and innovative order? Well, I do not want to say furthermore here.
This will not,
I will not say furthermore here.
this.
Lord, that much I can tell your lordship.
I
In
can.
the Supreme Court, I am not saying.
Not allowed.
Oh,
Sorry.
Already disposing of this.
Until High Court order is modified.
Petitions arising of the interim order dated T12/2025, passed by the High Court of Calcutta. High Court at Calcutta. In WPA numbers.
Yes.
Number.
Look, they have allegation against all the judges, even with the Supreme Court judges. It's common.
Having heard the learned counsel for the learned senior counsel for the petitioner commission and the learned counsel on your own caveat.
Caveat.
And the learned
Lord, I am appearing for the state. I am appearing for the state, Lord, in item 42.
Caveat from the original petitioners.
learned counsel on caveat for the original writ petition. For the
Item
writ
18,
petition
item 18.
before the High Court, semicolon, and Mr. Swansea for the, and the learned senior counsel appearing for the state of West Bengal. We are of the opinion that it would be appropriate for the High Court, which is still seized of the matter, to hear the parties on all aspects after inviting necessary writs and necessary counter affidavits and rejoinders thereto, if any, without undertaking this comprehensive exercise, it would not be proper for the High Court to pass interim orders summarily, which would have a wide-reaching impact. We accordingly direct direct the interim order passed by the High Court, on 3/12/2025 in abeyance. Still, the matter is heard fully by the learned judge of the High Court and reasoned orders are asked. Don't say reasoned orders and comprehensive. What did I say last time?
We accordingly direct the interim order passed by the High Court to be kept in abeyance till the matter is heard fully by the learned judge of the High Court.
And the final
State should will file affidavit in certain time, otherwise they will go on hearing.
interlocutory application or in the writ petition.
The state should file affidavit in certain time, otherwise the matter will never be taken up.
उधर लगाओ दूसरे वाला में.
File the affidavit. This is a vacation.
Because there are so many of them.
After 3 weeks after vacation.
The High Court
After vacation.
Time frames for the completion of state and proceed in the matter thereafter.
You will be permitted to give an
It said that the High Court will fix time frames for completion of the proceedings and then pleadings and then proceed in the matter expeditiously.
And it will not stay.
The order has been kept in abeyance.
Kept in abeyance.
Kept in abeyance. This is all right.
Kept in abeyance.
Same. Cut that into one step.
Item 19, debt default admitted, appeal, my lord, filed only on.
Interim order.
Yes. So it is an interim order, my lord, but there may be a subject jurisdictional issue. Debt default admitted.
But it still takes some time. Is it not? This Form G alone is now placed.
And 14th is coming up.
January.
Yes.
short circuiting the NCLAT.
Two banks have now been permitted to be included. Lordship just gives me a minute.
Short-circuiting
But once debt and default are admitted, 7 automatically follows. If they are coming up with a settlement offer, and that is the only argument recorded by the appellate tribunal, but the procedure to be followed is they must file a 12A application before the NCLT.
Raise all issues before the.
And secondly, my lord, that itself is in dispute. Whether your lordships have said before 7 you have to apply your mind as to whether or not you should go in for an IBC. And very similar to the old days.
Mr. Solicitor.
Literally in that side.
My lord, he was in the middle. I think now he's moved
Firmly that side.
What has happened? I'm the bank. They were my debtors. They they hang carrot more than 5 times different 5 offers. They started with 200, then they ended up with 400, etc. But they could not fulfill.
You assigned it.
Any of the promises. Yes,
they had consented to my OTS, who Mr. Mehta is appearing for, consented to my OTS, and then the other bank went back.
That's not correct.
Canara Bank.
If you permit, I can complete my sentence at least, if not arguments.
I think that should be done in the NCLAT.
Yes.
I'll maintain the decorum. Lord, thereafter, my lord, the settlement, my lord, did not go through. They filed a writ petition. We opposed the petition. There is a detailed judgment of 30 pages holding that our not accepting the settlement and our going in for the auction, my lord, is a legal legal proceedings.
Right.
My lord, in that auction, my lord, my learned friend was the highest bidder, my lord, and he is now, my lord, the assignee of the debt. Thereafter, they approached the Honorable Division Bench by way of an appeal. My lord, there, the Division Bench, my lord, gave them an option, and this is important, which may, my lord, appeal to your lordships. Division Bench said that if you are genuine, if you really have money, and if you are capable of discharging your debt, match the price they have done, they have offered. They could not do that, my lord.
They could not do.
They could not do that. Simultaneously, they were, my lord, using that order before the NCLAT. Now, my lord, NCLAT, lord, therefore, my lord, we pointed out before the division bench that they are misusing this order, and therefore, my lord, recording everything, even appeal is dismissed. Now, my lord, what happens is, your lordships are aware, in section 7, now what is required to be seen by the NCLT is whether there is a debt, yes. Whether there is a default, yes. If 2 things are satisfied, Lord, the merits are not to be gone into. Lord, therefore, admission order is passed. It is that interim admission order which is the subject matter of appeal. Lord, we pointed out, Lord, I'm out, Lord, he is in. But we pointed out that look at my experience since last 5-6 different occasions, he has been giving me the rosy picture and unable to fulfill anything. Now, my lord, the difficulty is, prima facie, it might look that only one form is stayed. Staying the form means.
Form G is invitation to.
So, my lord, everything is stayed. Now,
This is only unnecessary for a reason.
every consequence is stayed.
But why will it be? Because earlier the RP has to invite claims, all that process will.
No, that is stayed.
That is stayed. My lord, that is the difficulty.
Form G is for.
For initiating the process. Yes, my lord.
Form G is for resolution plans.
Expression of interest.
Interest, that is.
Inviting an expression. Inviting.
My lord is right.
Expression of interest for the resolution plan.
Yes, my lord.
Before that, he'll have to invite claims and all
That is state.
My lord is
That
right.
is
That is
state.
not plan.
But 75
is only for the plan.
75 days may not will be needed for expression of interest being invited.
I'm
More
sorry.
than 200 to 300 days will be
With
taken.
regard to the claims.
No, my lord is right. This is wrongly advised. Your lordship, expression of interest,
has been
everything
done.
goes on. Only the plan part will be stayed. That's
And
way later.
G is
75
only
days.
for, my lord, explain.
Form G is only in relation.
For expression
One
of
more thing.
interest.
One more thing, Malaj.
Claims are invited, claims go on. G is only for
And Malaj,
expression of
one more.
interest.
Interest, that is for the.
That's
And
all.
Malaj,
So
one
third
more
party
thing.
rights.
What is my learned friend saying, Malaj?
This other process can.
Yes, that is
Claims.
claim to submit.
And what is Mr. Mehta?
But only one request. If
What
form
is
G
Mr.
is
Mehta?
issued, if tomorrow, my lord, the appeal is to be allowed. My lord, anyway, the resolution plan approval would take 200 to 300 days. Matters have to come back before NCLT for the purpose of approval.
All that the NCLAT says is
14.
submissions advanced by the learned council need consideration. Not that it is held against you.
Correct.
They just want.
That's why
No, my
they
lord,
give 75 days.
The matter.
But COC is constituted.
Yes.
My lord, the NCLT now
We have
permits them to
reviewed
implead
the
the bank. The banks would have to appear, they would have to respond, my lord.
However,
Respond would have to be
there is no
rejoin.
Form G.
Though it is unnecessary,
That's all
Lordship
it
should
is.
know one thing.
The
One
practical.
Your Lordship should know one thing, Malaj.
Just one issue, it means this.
Lord, this would take about 200 days, my lord. The matter cannot be heard practically, my lord. Appeal cannot be heard
Why?
before that.
Why?
Lord, because of the backlog and everything.
No.
Lordships may consider saying.
It says 14-1 at 2 p.m. high on the board.
That should not be a self-fulfilling prophecy on their side.
That date, that
Not
would
just
be meant.
that.
No, the lordships may see, my lord, page.
It's a
page-
self-fulfilling
Time
prophecy.
to the respondents to file reply. 1 week time is allowed to the appellants to
Page
file
5,
rejoinder.
page 5,
So
para
obviously
9.
you're expected to do all this by the time the.
They want a self-fulfilling prophecy.
Page
only.
5, para 9.
Matters with
Page
this order.
5,
My lord,
para
I
9.
don't blame the NCLAT. Lord, it's a backlog. Lord, that's the problem.
We'll
But
say
Lord,
that.
what I am suggesting is, Lord, whatever happens may be subject to the appeal.
No.
We will say that the NCLAT will endeavor to take up the matter on this.
My lord, only one submission. Lordships may just see para 9.
We've seen that.
My lord, now the two banks have been permitted to be implemented.
They've already been.
Notice would have-
Amended memo is also
No,
issued.
my lord, but notice has to go to them. The matter is coming up for the first time on this date. Once notice goes to the banks would have to reply, banks would have to respond, and they will have to rejoin. Matter is not ending anytime soon.
Notice is not issued.
No, my lord, this has been permitted to implement. The matter will now come up on that day.
For-
But I therefore one
Lordship
submission.
to
But I
short
therefore
circuit the
one
hearing.
submission.
Allow me to
My
just place.
lord, no, my lord, I am not completed, my lord. I want to make one submission. My lord, there is one matter relating to the admission of the matter which is now appealed against. Your lordships have held OTS is not a matter of right, it is in the discretion of the banks. My lord, my learned friends' clients have rejected the OTS. They understood that they cannot canvass the validity of this rejection before the NCLT. They go before the Delhi High Court, file a writ petition. They don't get an interim relief. Division bench will
On
dismisses the appeal.
merits, we are totally in your favor.
Not only one
No
submission,
issue of that.
not only one final submission.
Had
May I
said-
suggest-
My lord, that's
May I
incorrect,
suggest-
my lord.
All
Let me
the
say-
states-
They will allow
I
you
don't
to
want to
say-
go into it now,
Submission.
but that is incorrect.
One final submission.
What they are saying
Final
is-
submission.
May I
One minute.
suggest- may I-
One final submission. My lord, they are now coming forward
allow
for the
them to
purpose
speak,
of
my lord.
making a proposal for the purpose of consideration. Now, your lordships have the 12A in mind, but I don't want to argue that. But my only submission is today, the COC is constituted, claims are invited. If Form G is issued, expressions of interest would come. My lord, the approval would have to come up before the COC. Eventually, approval application has to be filed before NCLT, which will take 200 to 300 days. This entire process will not go through if the appeal is going to be dismissed.
No, well, that's
Even if
wrong.
it is for 50 days, 100 days. But I'm making.
Now, allow me to
I'm
say
making
something.
one
I have
submission.
not spoken.
The submission I'm making is,
Well, then,
if your lordships were to please to just modify that, Form G can be issued,
No.
but the resolution plan cannot be finalized till appeal is decided.
Now let me explain,
The
Manoj.
process can start. They cannot be prejudiced.
Number one, Mr. Mehta can't go on. I've not spoken.
We have not finished, sir. We have
Every time I
You have
speak.
assigned your
You are
What is your interest when you have assigned?
Mr.
your-
Mehta's,
you are for the same party. We are for at least different.
On the lighter side, I have a suggestion.
Let me disabuse.
You have these sports events, is it not? You must also have one event where you should test the highest
decibel.
Highest decibel. So whoever is
Mine has increased 10 after I came here.
Allow me to say something.
There are who will come
I
uncontested.
really want to see who wins.
Allow me to say something.
If you have such strident tones.
Lord, there are two.
Really wonder who
They are not allowing this
There
man
are
to speak.
two who will go who will come uncontested. None of us would not stand a chance.
Oh, who is that?
I cannot say that.
Oh.
I cannot say no.
Those two names.
My lords, remember Alice in Wonderland, your old father William. Why your joy so much?
Lord, only one thing. The difficulty is we can't close, my lord, the mic here. It's not in our hand, my lord. We have
Some
no.
of you don't need microphones also.
I want to close it, but I cannot. Lord, Lord, and this would appeal to your lordships. The entire issue is they say we are ready to settle for 600 crores or whatever amount. Correct, my lord? That is what has weighed with the tribunal also, NCLAT also. Let them at least deposit that amount and show their bona fides.
Now, can I
Because I am saying that since last about 2 years or 1
I've
year,
had several attempts.
Lord, there are several attempts. They said this amount will
Well,
pay, this amount will pay, this amount will pay.
What?
And ultimately, eventually, if nothing is to be coming in the kitty,
Now,
then, my lord,
just two or three. Now, number one, date is 14th. Why was this order passed? Because I had the privilege of arguing it. Just 2 minutes. I'll not take more than 2 minutes. What my learned friend, Mr. Mehta's client, doesn't tell your lordships is his client invites an OTS from me. First invites, gets an OTS from me, approves the OTS from me, and then declares me a successful bidder. And declares me
supposed to pay 9.
No. Another bank did not approve the OTS. No, that's not what happened.
Please allow me. Canara Bank.
I've been aborted again, Manoj.
On 13th June 25.
I've been aborted.
Asked you to pay.
But then says Bank of Baroda is not approving. No, my lord. You were told you had to go to Bank of Baroda for approval.
I don't like
Bank
to
of
interrupt
Baroda
this.
kept that approval pending. That's what happened.
Now, Manoj,
Anyway, my lord, let us argue it in full in the NCLAT on 14th.
What objection do you have if they say that the resolution
My lord,
plan?
because
let me answer that.
my lord,
Your lordship asked a question.
third party is coming to pay. I'll explain to my lord. My lord, once expression of interest, third parties come in, the very delay my learned friend is worried about comes in because third parties are then impeded. Third parties have something to say, the very delay. My lord, I'm making a suggestion.
Delay because
My
of
lord,
the stay now.
whatever request they are asking,
IBC has to work with
whatever request they are asking, let them do it on 14th and add in an order till 14th when they can come there and say whatever they want. It's placed on 14th, high on board. My lord, normally your lordship under an appeal either to 136 or otherwise would not interfere at this stage.
Otherwise, we'll just
14th.
give you a date after
No,
14.
this is
and just make it
this is
clear
a
that we
statutory
Manoj may just dispose of it, saying that they will endeavor to hear it on
find
14th.
from the order impugned in this appeal that the NCLAT, New Delhi, Principal Bench, New Delhi, proposes to take up the matter on 14/1/2026 at 2 p.m., high on board. We are certain that the NCLAT, being well aware of the mandatory time frames fixed in the Insolvency and Bankruptcy Code 2016, would proceed to deal with the matter expeditiously and perhaps conclude the matter on that very day itself.
Bro, would your lordships consider requiring them to deposit something? They are enjoying
We are
the
keeping this matter pending. We're not
Matter is pending.
please.
list this matter on the appeal on 19th January.
Grateful. And my lord, your lordships may consider doing something, my lord, where we can stop this. This is not, my lord.
Oh, you can't.
We can't.
We cannot.
All of us try to do it.
We cannot. We cannot.
It has to be
I
done.
think
You
we
can
cannot.
Turn it aside if your voice is.
That's what we do.
You don't need a microphone.
My lord, there is,
You can always just.
my lord, on a lighter note, my lord, No, nothing to do with the matter.
No, but you must seriously consider having this as part of your sports competition. We would also be very interested in knowing who wins that kind of competition.
My lord, this bench
He's
will
given
not
us a hint, but he hasn't told us who.
because everyone knows.
I see. We don't know, Mr. You can't be unfair to us. You say all of you.
No,
know.
there is one incident, my lord, one incident. Winston Churchill was the leader of opposition, your lordships are aware. He was sitting in his chamber in the House of Commons. And in the corridor, there used to be public telephones for being used by the by House of Commons. So somebody was talking to somebody very loudly. It was being heard in the chamber.
No.
So Churchill asked this PA that who is this man who is shouting? Because Mr. So-and-so honorable member is talking to someone in his constituency. Churchill said, ask him to use the phone.
We'll just add one sentence. The NCLAT can also change the interim order if it's so chooses.
My lords need not say it. It is always because if your lordship say that, if your lordship say that, it seems so
Ashok Bhushan is not.
He would not, but it seems.
No, not your lordship.
Otherwise, put it differently, my lord.
They are taking a gamble. They are taking a gamble.
Sorry. Otherwise, my lords, put it slightly differently. It's open to the party to seek any change in the order. Instead of saying NCLAT can change.
That also, what difference does it make?
That's all. It's open to the party to.
If I don't seek a change, they will say they have not even sought a change, notwithstanding the liberty granted.
That's
if I seek a change and
Why
file an
don't you
application,
say it's
moment I seek a change, they will say I will need to file a reply.
That's
That
the
matter.
that's the
They are
My
being
lords,
clever in the
my lords, your lordships will say it's open to them to press for any alteration of the order.
They are
It's open to the NCLAT to also
That's
modify its order. That's it.
right.
You argue that on that day.
They will now use it to say your lordship's imprimatur. Change the order.
It's open. It's open.
It is always open. It's always open.
Obliged.
Sentence to be added.
Your Lordship, I'm appearing for the petitioner. Your Lordship, this is a matter which has between the complainant and the petitioner, there was a long litigation.
Sorry?
Over a land dispute.
It's
Your
online.
Lordship.
Yes. Yes.
And Your Lordship, thereafter, the complainant
Counsel, how do you maintain a special leave petition against a withdrawal order? What exactly are you to say that your matter ought to have been withdrawn?
Your Lordship, it was wrongly.
Explain to us what is the logic of filing a special leave petition against an order recording that you wanted to withdraw the matter and accepting your request and dismissing the matter as withdrawn. After that, you seem to have asked for correction of it. The correction is dismissed. That order is not challenged. So we are not even on the issue of whether you were entitled to ask for correction. We are only on the withdrawal order. There is nothing there that we can say.
Your
Lordship records that you asked for after arguing for some time. What? After some arguments, the counsel for the applicants wants to withdraw the application with liberty to file a regular bail application. That is accepted.
Your Lordship,
what kind of case?
Application for correction of the order, Your Lordship.
You have not challenged.
We have made an exit part of this SLP, Your Lordship.
You have not challenged it, counsel.
Yes.
We also look not only at your docket, but at your prayer in the SLP. You have only asked for setting aside of the withdrawal order.
Yes, Your Lordship.
In your mind, you are doing injustice to your client. Are you not? What is it that, what kind of relief do you expect from an SLP which will file against a withdrawal order? This is unfair on your part.
Your Lordship, if you permit, may withdraw the SLP, Your Lordship.
Counsel, having argued for something, then counsel for the petitioner seeks permission to withdraw the special leave. Especially petitions of public agencies.
Item number 21.
Conclude the delay. Conclude the application also stand.
Lord requires. Lord, requires consideration for straightaway, my lord, for one reason. My counsel has expired. His son goes and informs the court that so-and-so counsel is dead. No, my lords, the counsel's son goes to the court because of finding his father's name and informs the court that he is no longer alive. The court, instead of issuing notice to me, my lord, now my lord passes this order.
This information was given to the learned judge.
Yes, my lords. That's not recorded in the order, but and second thing, but no proceedings happened except that one way.
The registry also should bring it to the notice of the
Exactly, but he was a well-known lawyer, and criminal rules of practice, Lord, Rule 138 clearly imposes an obligation on the court, Lord, to issue notice.
Who is the learned counsel?
Yes, my lord, I have imposed Usman Sheikh, my lord.
Usman Sheikh.
The well-known lawyer in Hyderabad.
Passed away quite a long time ago.
My lord, yes, my lord, 24, my lords. 2024. Lord, he died on 22.
She would not have known him.
Pardon, my lords?
She is a service judge, so she would not have known him.
No, my lords, but instruction.
As you said, he is well known. Yes. The other side counsel should have informed the court.
Execution should have informed.
According to you, the son came and informed the learned
Yes,
judge.
that was, my lord, on the date. I have stated so in the list of dates.
Exemption from surrendering has been
Granted, my lord. My lord, Justice Alokarade had granted me exemption initially for a limited period, then confirmed.
I think we need to even keep it pending then. We'll set aside
Yes,
this order and send
yes, yes, my lord. I'll be so grateful.
Considering the circumstances in this case, we are of the opinion that there is no necessity to issue notice and put the. Is there anyone appearing on?
No, it's a freshman.
No, advance notice these.
No, that circular came after this process.
We see no reason to. What did I say?
We are of the opinion that there is no necessity to issue notice.
And put the state of Telangana on notice, or afford it an opportunity of hearing. The improved order itself records that the learned counsel for the petitioner was not heard. We are informed that the learned counsel was on record for the petitioner expired on
22/12/24.
22/12/2024. The learned counsel was fairly well reputed, and his expiry ought to have been brought to the notice of the learned judge, be it by the registry of the High Court or by the learned counsel appearing in the matter. In effect, the petitioner was not even given a hearing before the dismissal of his criminal division, as his liberty was involved. The High Court ought not to have proceeded to deal with the matter on merits without even hearing him. Hearing the petitioner. Full stop. That the impugned judgment and order dated 16/9/2025 is set aside, and the matter is remitted in criminal division numbers is set aside, and the matter is remitted to the file of the High Court for consideration afresh on merits. You were on bail?
Yes, yes, I annexed that bail order also, my lord. That's at page 127, 126, 127.
The bail order passed in favor of the petitioner during the pendency of the revision. Bail order dated 23/10/2007 shall stand revived and will continue to be in operation till the disposal of the revision petition on merits after hearing both sides.
So great. But in fact, para 2, where the court record that several adjournments none appeared. Not we inspected the court record, it was never listed.
That is also incorrect.
There was only once it was listed, on which date the son goes and makes a statement that my father
retired now?
No idea.
She was on the verge of retirement.
Still there.
She's still there.
But can it be assigned to a different court?
By the time it goes back, she might retire also.
So great.
Please, Your Lordship. Lordship, the postmaster.
Yes.
27,060 is the embezzlement amount, Lordship. Your Lordship, the account holder did not support the case of the embezzlement, Your Lordship.
No, but please come to pages 7 and 8.
7 and 8.
The embezzlement details are set out.
My Lord, out of the record only, and the statement.
This is what the appellate court has recorded.
My Lord,
Translation is here.
kindly have page 93, Your Lordship.
No, but look at what is stated here first. Account holders handed over money to the applicant accused to deposit the same in various accounts. He did not deposit the whole of the amount. So each time there's some amount given to you, a part of it you pocket. Detailed statement has been given in his own writing. According to the same, deposits of 500 rupees were made by Chandan Ben. He did not deposit the same in her account.
My submission.
Committed embezzlement. Sushila Ben handed over 1100 and 300, same not deposited. He committed embezzlement of 1400. Then Babu Bhai, 400 rupees. He gave 100 rupees as withdrawal and then committed embezzlement of 300. So these are the acts which are attributed to you.
My Lord, but these persons did not support the prosecution story.
But these are.
My Lord, these
persons were
out of the inquiry, departmental inquiry.
The departmental inquiry. Yes. This evidence is not from the trial court record, is it?
No, my Lord, it is on the record. But this person, postmaster, himself informed to the inspector of the postmaster.
No, who turned hostile? All these three persons
all these depositors, Your Lordship.
No, this Chandan Ben, Sushila Ben and Babu Bhai, did they turn hostile?
Kindly have page 93. A trial court judgment, Your Lordship.
93. Yes.
93. Last 4 lines, Your Lordship.
Yes.
This is the finding of the trial court. Of course, the account holder have been examined by the prosecution and they have not given completely the evidence to the effect that from their account the above amount has been misappropriated.
No, but this record which I have read out is from the appellate court's record.
My Lord,
So the appellate court records that this is the evidence against you.
Entry has been proved, Your Lordship.
No, but the witnesses obviously did not turn hostile then. How would the appellate court rely on these statements if those witnesses turned hostile?
My Lord, the finding of the trial court is that they did not completely supported the prosecution. Partly they supported.
I don't know what that means. Because these statements are sufficient to show that you embezzled the amount. Then,
My Lord, it could be a case of the
concurrent
falsification.
findings now, what you want? There's nothing that we can do. 477 days. That is the only thing. Delay condoned, however, we find no good ground and reason. Interfere with the improved judgment passed by the Act, especially petitions.
Fellows, I'm requesting for the pass over. Main council is currently engaged in another matter in another court. Much obliged, my lords.
Accused number 7 and 8, their question petitions were dismissed by the High Court. Lords.
34 is there.
Lordship, please.
34 is also there.
Yes. Lord, they are not connected with the family of the deceased.
No, but you're supposed to have threatened them.
No, Lord.
Threatened the complainant, asked for 2 lakh dowry.
No, Lord. I am not from the family of this person. Lord, may I just see my
washing though.
Lord, they are, Lord, the role of accused number 7 is that he helped in organizing the love marriage of the deceased with the accused number 1. He belongs to the same village. There is no relationship as such between accused number 7 and 8 with the family of husband.
Sure, A7 and A8.
Yes, Lord.
A8 is supposed to have threatened him.
No, Lord.
The complainant saying that A7 is an advocate and both of you would.
A7 is an advocate, Lord. He is practicing for registration of documents, etc. He had
a case for caution though.
Lord, may kindly consider. Para 6, Lord, may see, and para, I'll just read few lines, Lord. Lord, may kindly see para page 12.
Delay condoned, however, we find no good ground and we can interfere with the improvement passed by the court, especially questions of
Lord, your lordships have held that the test of 141 is that in the complaint itself, Lord, you have to plead 2 things as per 141, that he was, Lord, in charge of day-to-day affairs and responsible, Lord, for the affairs of the
Well, there seems to be enough evidence to prove that you were definitely in management of the affairs.
Lord,
you filed a writ petition on behalf of the company in 2020.
Only one writ petition is what I have filed.
Well, you've not filed a copy of that writ petition to see
can we do
how
that?
you describe yourself.
Can we do that?
Why? This filling up lacuna, we already.
No, it may not be
Filing again.
lacuna. No, in your lordship.
Selective filing will come back to bite you.
We can't run away, although I am saying that lordship may at this stage
What
admit that yes, I had filed the
We
request.
draw the adverse inference straight away. We don't need to give you an opportunity.
Let's argue in
This
this.
selective filing is sufficient in itself.
I can't say that the High Court has wrongly recorded. I must have filed, not that.
You filed it obviously, and in that document you would have described yourself, one way or the other. So obviously you don't want us to see.
Therefore, it is no.
So that petition is not filed.
I have not even taken a ground on that. Even if I have filed a writ, I have filed a writ, no doubt. But can I show my lord one judgment
You
of
find
the
no
Lord?
good ground and reason to interfere with the improved judgment passed by the High Court.
Lord, your lordship has said.
Recording be dismissed.
Lordship has said that in the complaint you have to plead. The complaint does not say so. The agreement is with the other director.
ROC's records also show that you were there as an MD. You say that you were CFO. We don't know what you were.
That
Whatever you were in management of the affairs. You file a writ petition on behalf of the company. Obviously,
That's
you're
the
a
only
head.
mistake I did, Lord.
No, that's it. One mistake is all that is.
I am not in the agreement. I am not signing the check. I am as your lord.
May I please your lordship? Your lordship is-
Did you bring it to the notice of the learned judge that he ought to have recused himself?
Not.
Did you?
Yes.
How did you do it? Did you file a written submission?
No, Lord, I, when the matter.
Orally.
Lord,
Orally you told him.
yes, I told him that my lord was the counsel in the matter.
So, yes, personally,
Yes, Lord, I am handling, I have been looking at
for the ED against the same.
directed, Lord. That's also, Lord, because he was the petitioner resigned from the director on 8/2000.
So there's no proof of your resignation.
No, Lord, there's a proof, Lord. There's a form.
You didn't even say it in the first instance.
No, Lord, form 30, yes, Lord. It is filed, Lord, and the impugn order discussed also, Lord.
This statement that you made that the learned judge ought to have recused himself, you said it in the presence of the other side?
Yes, Lord.
The other side was represented?
Yes, Lord, yes, Lord.
Will they?
It is recorded in the order sheet also. I have informed that Lord was the counsel.
Where is it recorded?
Lord, in the order sheet of the matter where he appeared against the company, Lord.
No, in this
No, in this it is not recorded, Lord. In this it is not.
So it's your exit against the other side's exit.
Yes, Lord.
Then how do we go by?
Lord, in fact, apart from the other fact, Lord.
You ought to have put it in writing, then it would have been stronger. If you had found
Yes, Lord, yes, Lord, because when the
saying that this matter
what happened is
not to be heard by you, then we can hold it.
Yes, Lord.
But if it's just an oral statement made by you, and then the other side will come and say that he
normally, Lord, normally, Lord, we mention it only the Lord was the counsel in this matter.
No, but
my Lord,
you're making it a ground before us. So you ought to have been more careful then.
I can give up that down to the other ground also.
In other grounds, we don't find anything.
Lord, the other ground is, Lord, the form 32 is there, Lord, DI 12.
Begin with, how will you maintain a discharge application in a summary proceeding?
Lord,
how would 251 allow you to file a discharge application?
Lord, we pointed out before the that I have already resigned from the company and I have not signed
In a summons case, how do you file a discharge application? There's no charge to be framed there.
Yes, Lord, that is correct. But the revision,
your very application was misconceived. Then what comes out of it?
Lord, but Lord, on the merit of the case, Lord, because Lord, form 32 go there, my Lord has held in many cases that where the person is resigned.
482, the High Court looked into it on merits because it's a 482. But your foundation is your discharge application. And on the basis of it, the discharge application was not even maintainable. That is exactly what the trial court said.
Lord, we can find Lord, there is a judgment of this on your Lordship, where if the director has resigned and there is an unimpeachable document.
That doesn't mean that you file a discharge application in a summons case. We find no good ground in reason to interfere with the extreme judgment passed by the High, especially petition.
I'm grateful.
R10 is still not served.
Oh. Somebody is not.
R10 is not served.
R10.
27.
I'm not aware of it. Don't you look at the office report? I thought.
So it was otherwise coming up for being.
What is the notes?
27, I've written that R10 is not served. Service of notice is not complete on respond number 10. It says so.
But in fact, this
No, it's a land
there's some
I don't know. Once we have a party who is
Not that, Miller. The state is in appeal. And he's a
It is in
land.
but we have R10 who is not served. So either you seek deletion of his name or
Lordship
you
may,
don't know who Arden is.
on our oral request, your Lordship may direct this to me.
No, we always insist on applications because it has to be at your sole risk and peril. So I'm not in the habit of exercising this one jurisdiction for the.
Your Lordship's are right, but he is a pro forma respondent.
Whoever it is, you need to file an application and ask for his deletion.
Lord, Lordship may have it immediately after the reopening.
You don't know who Arden is. Who is he, Lord?
Lord, he is a land acquisition office.
He's implicated by name though. For what reason?
That's correct, because it arises from contempt.
Oh, contempt. Then counsel for the petitioner seeks some time. Seeks time to take necessary steps in relation to unserved respondent number 10.
May I
Grateful.
request for a specific
List on.
date?
Yes, we'll give you a specific. That some money was also demanded for compliance with your.
That is when the tables turned.
We'll give you a specific.
Can it be an NMD?
Sorry?
Can it be a non-miscellaneous day?
Non-miscellaneous day. You want to join the queue?
Well, what would happen is it would
Very
difficult. It would be
28 January.
taken up. If it's a
28
miscellaneous-
January. You'll join the queue, then it will
But
move
the
on.
notes are filed. Well, sir, in fact, a year
It may
apart.
not be a matter for a miscellaneous day anyhow. So let it come up on Tuesday.
Great.
I'm waiting.
My Lordship, kindly allow us to submit the physical appearance.
Yeah.
Please.
Your Lordship, a letter.
Letter is there.
Let it be. And for the respondent.
One was enough. You didn't have to give 3. Viral fever, bad throat, chest congestion. It is sought by the Joint Council for the petition.
One can suffer from all the 3.
Interim order dated, the matters accordingly adjourned, based on 16 February. Earlier status quo order dated 18/8/2023 shall stand extended in the next year.
You're grateful, my lord.
While issuing, this was application for condonation of delays rejected.
24 days today.
24 days.
24 days notice.
I beg to appear for respondent number 1, the private party, Your Lordship. In my humble opinion, the High Court has rightly.
24 days. Morse brothers also.
Your Lordship. Your Lordship. So in that case,
24 days is hardly.
yes, the petitioner may be directed to deposit some amount, Your Lordship.
No. This let the
It's a 2014 proceeding, Your Lordship.
Let the appeal be heard. Whatever you
So
wish to ask for.
any timeline may be framed.
No, you can't fix a time frame for a high court.
2017 supplementary award, Your Lordship.
The appellant, the National Highway Authority of India, is agreed by the judgment and final order dated 17/9/2024, passed by a division bench.
No, but not single judge.
Single
It came
judge.
from the district court.
Passed by a learned judge of the Allahabad High Court, refusing to condone the delay of 24 days in the presentation of the appeal by the appellant under section 37 of the Arbitration and Conciliation Act 1996. In the light of the judgment of this court in both cases, you have the citation.
We will give the citation.
Course is still a bit open-ended.
Lord, it's 2021, volume 6, SSC 460.
460. It is not, the delay of 24 days can hardly be said to be exorbitant or inordinate. It is, the appeal is accordingly allowed, setting aside the interim judgment and order by converting the delay of 24 days in the presentation of the appeal under section 27. The High Court shall restore the appeal to the and consider the same on its own merit and in accordance with that.
Grateful to us. Obliged.
The appeal is allowed and the appreciation.
Madam, one of the main respondent number 5 has not been served, madam. Sorry.
Rejoinder to R1's contest. You want to file a rejoinder?
Yes.
Adjournment is sought. You are for the union.
I'm for the union.
Who appears for the state?
I'm for
You're not
126. No, so the Delhi VAT government department has been served,
No,
but
but
I think
this-
Maharashtra
State
VAT,
of Maharashtra has not been.
they have made all of them parties.
Maharashtra state is also a party?
Yes, madam.
Maharashtra state, for some
Why is
reason,
the
is a
state
party.
not
No, no. Actually, my lord, the sales tax department is demanding sales tax from us.
But have you?
Service tax
implemented the
department is
state
demanding-
or have you implemented officials of the state?
No, no, only the state, madam.
State department.
Deputy
State sales.
Through the deputy commissioner.
Deputy Commissioner. Respondent number 5.
State of Maharashtra Sales Tax Department.
Department through
Who is not served now?
Only the respondent number 5.
Five melons.
Five.
Everybody has been served.
Let us see how you describe.
Yes, madam. Page 25, madam. The party.
page 12.
That's the reason. The state will not have a sales tax department.
Or your lordship
Some
can give
commercial
me.
taxes ministry or something must be there.
Say-
But it won't have a sales tax department. Where will the notice go?
Your lordship can give me the estimate, I will serve it.
So Rusty must have been permitted. Neutral order is.
No, no, it is
all
not.
modes including Rusty.
It is not there.
It is.
I'll serve the ST then.
21st February, notice will be served by all modes including Rusty.
I'll serve
So
that.
in spite of that, you were not able to serve. Respondent number 5 still remains unserved. Then counsel for the petition shall take necessary steps in that regard. He is also permitted to file a rejoinder to the counter affidavit filed by respondent number 1. List on 23rd February.
Item number 31.
31 perhaps needs a hearing.
Your Lordship, we would seek time for a rejoinder. in this-
Some laser imaging with
Yes.
3D
Yes.
medical equipment. Duty is already paid under protest.
Madam, some amount of about 5 lakhs.
Your Lordship,
Five?
we re-
About 5 lakhs. We are not in appeal, they are in.
There in 5 lakhs, just 5 lakhs.
Your Lordship,
For 5 lakhs you want to fight.
we're requesting time for a rejoinder.
Perhaps it will have a cascading
I
effect.
don't think so, my lord. It's very specific. It is one piece of equipment, and I think based on the description, it's now obsolete. It's like a laser printer. We don't even use it anymore.
For this, Lakshmi Kumaran and Sridharan is engaged for 5 lakhs.
Your Lordship. We will
Very
request time to file
Just
the
give me a
rejoinder.
date. You cancel for the list for hearing. We'll take it up on a Tuesday.
Madam.
And you can join the queue and move up the list.
Obliged.
17:30.
We are led by learned ASG, my lord. He is on his legs. So, see.
Council affidavit is not there.
Yes,
But
my lord.
I'll tell you this. This matter, there was a dispute about the classification. That dispute got decided against the SSCs. Right from the beginning, I was pleading that even if it is decided against me on the merits, if duty cum price is taken and the duty element is deducted, then the dispute will be hardly for a small sum. This honorable court in the main judgment did not go into that, though recorded my submissions. Then I filed the review petition. The review petition is decided by this honorable court. If lordship only kindly says page 337.
57.
337.
My lords. A short date.
Just a second. I'm not opposing it. Just a second.
We will not pass an order against you.
Yes, thank you.
Let us understand what we learned council is saying.
I'll come to page 337.
Yes,
Kindly see the last paragraph.
yes.
In view of the aforesaid position, SESTAT should decide the appeal preferred by the petitioner Urmin Products, limited and restricted to the question of quantum of computation of cum duty price. No other issues to be gone into. Now kindly come to the tribunal's order
Yes.
at page 4. May I take a lordship straight away to page 9.
Yes.
after quoting this honorable court's order, then they discuss about the chartered accountant certificate. If the excise duty is deducted, then what to do with the differential amount quantified? If Lordship kindly turns the page,
Total amount.
total amount realized, then how much is the duty payable, how much is the duty paid, differential excise duty yet to be paid was 5,42,000. So that is what was decided exactly in terms of this honorable court's order. Now kindly see the notice issued by my lords on the current SLP of the department.
Yes.
Can you have a look at that? It is submitted that the impugner is perverse and does not notice the contentions and allegations made by the revenue and also the findings recorded by this court while accepting the figures and data given by the respondent. Now all these figures and data were right from the beginning there. Nothing new was there. Even in the review
Nothing new was brought.
Nothing new. Even in the review petition, the same figures are there. No counter was filed
So
there.
according to them, how much should be the differential
Well,
excess?
that was 10 crores.
They claim 10
They
crores.
claim 10 crores. If excise duty is deducted, because 67% of the duty remained. If that 67% is deducted, the assessable value comes down very substantially.
Right.
The differential duty comes to only 5 lakhs. If the tribunal only followed the directions of this honorable court.
We'll see. We'll give you a date anyhow. This matter, perhaps the other side will want to argue it.
Definitely, I don't want to take any expert order.
Well, no, in any event, but
Definitely.
Mr. Venkatraman does not let go easily. You must be knowing by now. So
We have been
we
knowing.
will argue at length, so we will give you a Tuesday so that he will have his say.
Very well.
10th February.
But then in the meantime, maybe also file a counter.
Yes. In the meanwhile, counter affidavit.
Very
maybe. Counter pleadings may be concluded.
Very.
Please, my lords. My lords, I am the successful OTS applicant.
This also requires hearing, perhaps.
Yes, my lords, it does.
In
It does,
this
my lord.
case, I hope the council for
You had a stay since.
I'm here.
February.
My lords. So, my lords,
There's someone who's trying to speak.
yes, probably.
Why is he not speaking?
Because the
I'm
issue
here,
is,
my lords.
I'm the liquidator.
Yes, you're for the.
I appear, my lords, for the contesting respondent,
Oh,
for the public corporation, my lords, in whose favor the appellate tribunal has given a finding that the lease deed that had been granted by it to the corporate debtor stands terminated. There are concurrent findings, my lords, in my favor that without obtaining permission from me, the liquidator effectively granted a lease to an entity which was basically a means to give a backdoor to the suspended management. The liquidator initially ran it. Yes, my lords, and the rules provide very categorically that if a sub
Suspended management.
my lords, the GST returns suggest so. And so this was something that weighed in the mind of my lords, the appellate tribunal.
You've not filed a counter yet?
No, my lords, I haven't, because in terms of the last order, my lords,
Yes.
they were to consider whether they could grant approval for the OTS. And my lords, no written instructions have been obtained by me from any competent authority, despite the requisite diligence.
May I
Pursuant to that order then?
My lords may just kindly keep it in January. Meanwhile, I could impress upon the authorities the urgency of this, because for some reason, my lords, they are not giving me written instructions. Whatever is being said to me is being said.
Probably.
The order said several things.
My lords, my friend is not aware of the facts, actually. May I just.
If you look at the order,
I'm aware, my lords, I'm aware of the last order.
then all these things which are to take place, this
Yes, my
OTS also may be considered.
My lords, that petition remains pending before the NCLT.
And
Your Honor, may I submit your
objections raised by with regard to creation of the sublease, that's been also taken up?
My lords,
Yes, my lords.
may I just submit.
Sale of the property as a going concern.
My lords, what has happened here is that after suffering the order from the NCLAT, the suspended management is seeking to compromise with the financial creditors. That is, my lords, that is their liberty.
May I submit, Your Honor?
Yes.
Your Honor, in this matter, actually, the suspended management has made OTS with the PNB, and PNB has already approved the OTS, and consequently, application for withdrawal of the liquidation proceeding is pending before Honorable NCLT. Your Honor.
My lords, this
The
is
amount has been paid in full.
No, Your Honor, only out of 30 crore, only 10 crore is being paid.
So, my lords,
My
may I
lords,
just
that
refer to page 5 because the respondents.
The matter is now pending there.
My lords, so
Yes, Your
may
Honor.
I just a moment. My lords, may I just submit that the respondent counsel is completely unaware of the factual sequence.
my lords, I've been handling, my lords, I would not take that
Allow me to submit.
because I've handled the matter before the NCLT and the NCLAT, so that is not a fair comment to
Allow
make.
me to submit.
He's appearing before both the authorities.
He does
No,
not
no.
have the proper instructions.
Before the tribunals, he's appearing.
No, I'll demonstrate.
How
that
do you not know what is happening?
But my lords, it's the record because the OTS was given as early as on 1st August.
No, but you've only paid 10 out of 30.
So, my lords, I will pay once the liquidation is set aside.
You want the order to be set aside as a condition?
No, my lords. There is a liquidation process which has to be set aside.
No, obviously you would have undertaken to pay the amount within a time frame.
And
What is that time frame?
And that application is pending.
What is the time frame for the OTS to be completed?
At page 549, my lords will find the application filed.
Are you aware of the time frame for the OTS payments?
Look,
The PNB?
the OTS, 1/3 has been paid.
Yes, Your Honor. Yes, Your Honor.
And balance, because my lords, I am the OTS applicant, I know.
Yes, but you're not telling us what the time frame is within which you are supposed to.
As soon as the.
Are you still within that time frame or have you already violated?
I'm within the time frame. As soon
When
as
is the next payment to be made?
As soon as the liquidation is set aside, I will pay the balance amount.
Is that how the OTS works?
Yes, my lords, that's how the OTS has been set. May I just refer?
Is that correct that the OTS proposal itself envisages the liquidation order being set aside?
Let's see 541, page 541 for a moment.
Why would the bank have agreed to that without even knowing whether you'll pay the money actually or not?
Just a moment, just see 541, everything will be clear. This is 1/8/2024, my lords.
541.
Yes, my lords. The next year, 8/28. My lords,
Next year, 812.
8/28, my lords.
541 is 812.
In my appeal, my lords, I am 33.1.
Oh, 33.
I am the OTS applicant, and 33 is the liquidator, my lords.
Which page did you say?
541.
Second one. Yes.
My lords have it.
Approval of OTS.
Yes. So this is 1st August 24, my lords. Approval of OTS offer in the NPA account of Narmada Serial. My lords, the terms and conditions are in the second para. It says upfront amount of 10 crores shall be paid before filing of application for withdrawal of liquidation. Schedule of deposit 10 crore is as under. Balance amount of 19.60 will be paid within 3 months from withdrawal of liquidation order. My lords, so I have paid the first tranche, which is 1/3 of.
When is your application coming up before the?
So this application, it's on 30th January, my lords.
30th. Then we will take it up after.
Please,
So,
my
my
lord.
lords, I keep it on a Tuesday after.
Interim order may continue, Your
I
Honor.
have to make the payment with.
No, after.
After the
Interim order may continue,
3
Your Honor.
months after the liquidation is set aside.
3 months.
1 month.
So we'll take it up after that. Let us see whether you.
Please, my lord.
Your Honor, interim order may continue.
List on
My lords, may I just point out, I have also filed an application for additional.
19th May.
I have also filed.
While proceedings to go on before the tribunal.
Well, it's the interim order to continue.
Earlier interim order dated 24/2/2025 shall continue to operate in the next.
Your Honor, meanwhile, pleadings should be completed because
Pleadings in these matters may be completed by the second.
Because they have not filed even a counter since then.
Then file your counters.
Yes, my lord.
What date has been given, my lords?
19th May.
My lords, may keep it a little earlier because this will.
Let's see whether you make the payment.
I will immediately pay as soon
Let
as.
us see. These kind of exercises we.
No, my lords,
many of them.
this is only pending because
Several times bitten, now try.
the NCLT has not been able to
don't
take
go
up
by.
the.
Let us see whether you live by that.
And there is one more observation.
Your Honor, may I submit something, Your Honor?
Yes, sir,
Yes.
just one second.
Because of pendency of this appeal before this Honorable Supreme Court, though NCLT may hesitant to take up the matter, so one line may be added.
It said that the tribunal proceeding shall go on before the tribunal.
There is one more issue, which I may just submit.
Next,
in the last order,
not necessary at this.
Just,
Let the act.
it will help the court. In the last order, it is said that in the meanwhile, proceeding for sale of property of corporate debtor as a going concern shall continue, which is no more relevant since the OTS has been given.
We don't know. Let us see. We
Yes, my lord.
continued the interim order. Now we are not going to modify it.
I'm grateful.
Please, my lords.
Lordships, in this matter, it was on a limited moratorium that we had approached your lordship.
No, but
Yes. So the only point which
that writ petition that you had filed also be dismissed.
no, but your lordships, as far as the
Only the civil appeal is pending.
civil appeal was pending, it was on the issue that as far as the 22nd January order was concerned, because what we had stated.
Now what happened there? Who's appealing against you?
Your lordships, that's what I want to point out, that as far as the resolution professional was concerned, unfortunately, he has passed away 2 days back only. That's what we have come to know. I may also fairly inform your lordships that there is a resolution repayment plan which was drawn on 3rd December. But all I'm urging is that let the other RP be appointed in the meanwhile, and then your lordships will.
Yes, 34. We're informed that the resolution professional,
Anil Kumar.
who was, what's his name?
Mr. Anil Kumar.
Mr. Anil Kumar, is no more. That is according to your judge, anything replacement to be appointed in accordance with the procedure. List on. We'll take it up on a Tuesday then.
Very well.
17th March.
Very well. Much obliged.
Item number 35.
So 35 is a matter arising out of proceedings under 351 of the MMC Act.
The position corporation lordships, they have not served as the rejoinder. The office report said is defective.
Actually, corporation has not filed the
They have not filed it.
So rejoinder will come once the counter.
President of the party members will need to have a look at it.
R1. You filed a rejoinder to R1's.
We have filed rejoinder to R1. If corporation wishes to file counter, they may do so.
The question is which respondent?
R4.
R4. Who's appearing?
So I'm appealing for the
R4.
Yes, madam.
You've not filed a counter yet.
No, madam.
So you want time to do that. And counsel for respond number 4, 6 time to file a counter after the proceeding. Usual order. Based on 11th February.
Lord, one request I make. There is a parallel separate suit, which has nothing to do with the corporation, which is a landlord-tenant suit pending before the small causes court. Now, that court is somewhat hesitant to take up the matter in view of the pendency here. One line that suit is unaffected by this may.
The pendency of the special petition should not preclude the proceedings initiated, which are not strictly connected herewith, from going on.
Obliged.
Beautiful.
Proceeding in accordance.
Item number 36.
This will take some time, but I still
filed a counter, my lord.
We'll give you a Tuesday.
Plus, your lordship said extend last occasion, not extended the interim order. The initial order, your lordship said
Goes without saying, madam.
no, the last order missed that out. I'm the only.
No, there's no question.
Your lordship see the first order. 25-8. Your lordship see there's an.
Shall remain state.
Please, madam. Absolutely.
This for hearing on 17th March. Earlier interim order dated 25/8/2025. We continue to operate.
Obliged.
Your lordships, in this matter also the pleadings are complete. Let it be kept on a NMT.
Your lordship, I'm setting the pass over as I'm being led by Mr. Call. He's on his legs.
We can't take up this kind
My
of
lord, I am here for the appellate. Can I just have a minute? Can I just have a minute? But I know your lordships have a partner. But lordships will have the first.
We have several.
I'm so sorry. I should correct myself immediately. My request is one. My lord, I should just make one request. The CIRP, even after the stay of your lordship's order on 9/9/25, is now held up. I am the financial creditor. My request therefore is, my lord, whichever date your lordships want to keep it after reopening. Lordships, no, because the issue is really now after the pleadings, issues narrowed down to only one point, that whether a Companies Act action can come in the way of an IBC action. According to the enclave, it can. So, my lord, my
Lordships.
request is if your lordships can't take it up today, my lord, any day after reopening, but my lord, at the earliest, so that we can proceed with this year. Time bound, my lord, that's the
In
only
this
issue.
case, I only want to
This is
point
that Punjab and Haryana pending.
Yes, yes, yes. Lordships had heard us
So
at
Lordships,
some length.
I think it is in the February or March, the matter is next listed.
I appear for the RP, my lords. The matters CRP proceedings were continuing. There is a successful resolution applicant. We have filed the plan, my lords. It was to be listed in, it is listed in January, but in the meanwhile, my lords have stayed the CIRP proceedings.
The Lordships is
There
asking
is
about
an
Punjab
amount
and Haryana High Court. The Lordships is asking about Punjab and Haryana. April. That is in April.
That's in April, but the SRA has deposited 4 crores, my lords. There's a plan for 23 crores.
Your Lordships, they are.
So it may be kept in, I'm only requesting that it may be kept in January, my lords.
Your Lordships, we have no difficulty, any date.
I can only say that the promoter can't object to my request for an early date, my lord.
Your
They
Lordships,
can.
I'm myself saying, let it be taken another day, any other day.
Let's
Any other
call
day
hearing
or
on-
IIT.
You'll join the queue, thereafter you'll move up. Oh, it's a civil appeal, so it can be taken up on a Wednesday also.
Lordship, please.
At least it can be listed on 28th January.
I'm deeply
Interim
obliged.
to continue.
In,
Okay.
Lordship may continue the interim.
Interim to continue.
Earlier interim order dated 15/9/2025.
Highly
Continue to operate in the next.
Much obliged.
I'm extremely grateful.
No, please, Your Lordships. Your Lordships, in this case, the state has informed me that they are seeking time, and there are other respondents that have not entered appearance. The other respondents essentially are the
not come.
correct, the sanctioning authority. My learned friend represents the vigilance. The sanctioning authority, I'll have to have served them again, Your Lordship.
You'll serve them, they serve though.
They've been served. The office report says that. They're a distinct
Directors,
corporation.
Principal secretary, directors, managing director. State has entered appearance. So why are you not entering appearance for your secretaries?
We have entered appearance for.
You only entered appearance for R1.
Milords, R1, 6, 7,
8 and 9.
What did R2 to 5 do that you want to disown them?
Your Lordships, the 2 to 5 are the PSCIC. That's a distinct corporation under the Punjab government.
Oh, it's a separate.
Yes,
separate panel.
It was represented distinctly even before the High Court, I'm told.
No, but 2 is the principal secretary, Department of Home Affairs.
Home Affairs.
Why would he not?
I will be seeking
No, but-
appropriate instructions, Milords.
Manoj, we'll take instructions on that, Manoj. We'll take
Yes.
instructions and
R3
necessary steps would be taken.
R4 is the Director of Industries and Commerce. And R5 is the Managing Director of
That's the
that
sanctioning
company.
authority. Correct.
Only the fifth respondent, perhaps you might not be appearing for. But the other respondents, you should be entering appearance. What about R5? Does it not have a standing counsel?
Your Lordships, I will have to take instructions on that. I'm told by the lawyer who argued it before the High Court that they were represented distinctly.
No, separate counsel. So you'll.
I'll serve them again.
And counsel for the petitioner is permitted to effect service of notice afresh upon respondent number 5 and file proof of such service. When counsel appearing for the state of Punjab shall ascertain as to whether he would also be appearing for respondents 2, 3, 4, 2, 3 and 4.
Your Lordships, interim to continue.
Earlier interim order shall continue.
Highly obliged.
Earlier interim order dated 15/10/25 shall continue to operate in this year.
Grateful to your Lordship.
We'll see when the matter reaches 39. 39 is a part heard again. So 39 is perhaps some less likely part heard to be taken up.
But today, Milords, it looks bright.
We've got too many part heards. Yeah. Time is less and this miscellaneous week has not helped. Had it been a regular week, perhaps we could have done a little more because Tuesday, we had to wind up because the one matter which we had slated for hearing collapsed. And there was only one that day. Yesterday, we had plenty, and today again, we have plenty. So let us see how it goes in the afternoon. 40.
Good. 40 minutes.
40.
My lords would see the FIR note. It is lodged under 306. My lords see the content of the FIR notes. No ingredient of 306 is made out.
But it's a quash petition.
Yes, my lord. It's a question.
Bail is one thing. Quash, they're less inclined to interpret.
No, not. In this case, that's what
I
I'm
don't know whether
306.
they make out a case or not. That depends again.
The FIR says there are multiple injuries because it says that all the 4 accused persons were beating that person.
He killed himself by consuming poison.
So that's what I'm saying, Lord. So there has to be an
case for caution. We don't know what evidence will be brought by the prosecution. How do we decide whether you left him no option but to commit suicide? That is something that needs to come in through trial. We find no good ground in reason to declare that the influence passed by the High Court, especially petitions according to this.
Item number 41.
Should we finish the
Petitioner's
early hearing?
Year-old daughter has suffered burn injuries on both her hands.
Early application, early hearing application.
It was supposed to be, it was.
We'll make the same noises that we did yesterday. Maybe you were not there. So.
Same. At least let it be taken up.
That's exactly, those are the noises we make. Hopefully, when it comes down to it, the High Court senses that a nudge is as good as a push. But I don't know whether the High Court would be sensitive enough to do that. So you'll have to perhaps apprise them that this is not just a nudge, but maybe a push. So we'll leave it alone. The petitioner is aggrieved by the dismissal of his early hearing application. This bail is sought on what ground?
Not the regular.
Charge sheet has been filed.
Charge sheet has been filed, but
charges are not framed.
Charges not framed despite 2 years, more than 2 years.
We find that the petitioner has been in custody since 24/4/2023, but charges are yet to be framed. In this context, his application for bail is under consideration. And then it is being adjourned from time to time, and the next date for the hearing of his bail application is stated to be 3/2/2026. Though we are not inclined to entertain the special petition in relation to the dismissal of an early hearing application, we would expect the High Court to be sensitive, to be conscious of the fact that the liberty of an individual is at stake, and consider the application filed by him, the bail application filed by him on merits expeditiously and if possible on the very next date of hearing, that is 3/2/2026.
Wait.
Item number 43.
43.
Please, Lordship, this is only my 2 submission is that one, the High Court vacated the interim protection for the reason alone. I have not settled with the respondent number 4, who made the proposal in my causing petition that if the amount so and so is being paid, I will be give the consent.
9th December, you had said in the other petition that you had paid the amount already. And that the proof of payment.
This is the same government.
No, but
it's a government.
look at the order which is now impugned. You asked for time to file a counter.
No, I have not asked the counter. I have no petition.
What is the order?
If you Lordship will see the impugned order, that is.
Interest is not extended.
It is there. If you Lordship, interim protection is not there.
Respondent seeks time to
file
counter.
My submission not been.
Respondent seeks time to file a counter affidavit. You wanted time to make the payment, is it not?
No, I have not. I have not wanted.
Did I get it the other way around?
Please, if your Lordship may see, please, if your Lordship will see the order dated.
R4 and purchase 2018. Yes, R4 paid 50,20,000. R4 said that he would be happy if you pay back the amount that you received.
Please, your Lordship.
You filed the writ petition to quash the criminal case, is it not?
Please, Your Lordship.
And you were supposed to make that payment.
No, I am not supposed to make the payment. That's the difficulty. If Your Lordship will see, if we appreciate the fact, if Your Lordship will see page 44, that is annexure P4. That is the order, first order.
Where is that order? Which page?
Page 44.
44.
Annexure P4.
Hmm.
Para 3. Mr. So-and-so fairly considered that if the amount which has been deposited through RTGS 21,25,000.
You took time there to ask for instruction.
So, be a question about this query. I said that I will take an instruction to my client.
Are inclined to settle the matter, you said.
No, that's this para number 7. The High Court says since the parties are inclined to settle the matter.
Very well.
Party is not inclined to settle
But
the matter.
your brother at page 47.
May please, Your Lordship.
You want to file separately writ petitions and say take different stands?
No, what is
Karamveer is your brother.
You-
Karamveer says
the payment
that
was
the
paid.
money was to be paid by the petitioners has already been paid.
For the reason alone, because of the complaints registered before registration of the FIR, the ACP.
So have you paid the amount? Have you not paid the amount?
Due to some pressure of the police authority, I paid. Some,
How much have you paid? Not the
8,
full amount.
not the 8 lakh something amount, sir.
Then obviously you're not entitled to the interim order. You were granted protection only on the ground that you wanted to settle the matter.
The subsequent order, that is a page 47. This is a subsequent order. The order
In your brother's writ petition,
that's a
that
20.
your brother is lying there, that the amount has been paid.
The amount is paid who are him, because what is happening is that
Where is the order that he will pay only a limited amount?
no,
The council for R4 said they would be satisfied if you paid some 21 lakhs and odd in its entirety. Not that each of you will pay a separate amount, so each one can be let off if he pays his component.
that
There is no such order.
If you Lordship will see page number.
Obviously, you're not entitled to the benefit of the interim order once you don't pay.
Lordship, please come page 25. If your Lordship, please see what actual total amount was. 50,000 was cash. 29 lakhs
We
70,000.
don't know how much is the amount. He said he wanted 21 lakhs and odd.
So that
You said you would get instructions.
the 8
On that basis, you are given interim protection. You're obviously not wanting to pay. So once that goes to interim protection also goes.
But sir, this is a civil dispute. I'm a
Sorry.
landowner.
This is an interim order now. We are not going to interfere. We are not inclined to interfere with the interim order passed by the High Court.
Petitioner is in 71, 65 years. They are the landowners.
Litigate at Allahabad.
The matter is coming on.
Criminal miscellaneous writ petition number 24286. Especially petition is according to this. 45.
Madam, we have given the details.
45.
Yes, page 59.
Now, we'll see that the West Bengal Board of Secondary Education wants 8 months' time or till the selection is over.
Selection
one.
The board is only, there are two parts to it, my lord, what the board has requested. One is the 11th and the 12th, where approximately what we are expecting is that the commission should give us the merit list by about 7, after which the counseling can begin by 15, and thereafter we'll have the list in about a month and a half or so. As far as 9th and 10th are concerned, the counseling is likely to begin around March of 2026 and February, March, and we will have the
counseling, earlier counseling is going on for 11.
one of the enormity we are looking at for every about say 30,000 posts or 35,000 posts or whatever, a ratio of 1.5 or 7. So you are looking at about a few thousand being interviewed, counseled, they're out of station students. The whole process is cumbersome and onerous. So by June, I think, my lord, realistically speaking, by June, this whole process should be
for both sets.
Yes, for both sets by June. By June, my lord, realistically, because I tell you, lordships, another problem will happen. Even when the recommendation from the commission comes, after the recommendation from the commission comes, the verification of certificates and documents by the board takes place independently. Secondly, my lords, the medical examination takes place. And thirdly, the police verification. There are candidates from West Bengal. There are people who change residences across the country. So this whole process, by the time, realistically speaking, we should be able to get over with it by June.
End of June?
End of June.
End of June.
When the initial order was obtained, it was given the undertaking that they could do it by December.
Now, well, the number of writ petitions being filed before.
That is nothing.
Obviously,
That has
100
nothing.
actions are pending and the
there was
one,
no
one
stay.
person who is most aware of it is my learned friend.
There is
Not one,
no
100
any proceeding.
My lord, I just
Lordship may extend
one
his
statistic.
but not in a 6 months.
My lord,
or
one
of June.
one statistic.
End of June,
200
will
read petitions.
whole
have been
intention is
disposed
to
of.
let continue
100
these
petitions
persons
are
who have been found to be without illegally appointed. 3 months is not enough.
Let it be 30th August to be on the safer side.
No, no, that
45
by February it was taken.
and 45.3.
Yes.
Yes. Delay condone. The miscellaneous applications are ordered. Granting extension of time to complete. What did we say in the earlier order?
31st December.
31st December.
And unless it was December, that my lord still end of June.
By extending.
This is Sakita's way, we ought to continue with the
Appointment process in relation to appointment process of teachers for classes 11 and 12, 9 and 10 on the one hand, and 11 and 12 on the other, till 30th June 2026.
I think 30th August will be.
But that's,
safer. They will not
there is
be
no
needed to
further
come back.
application.
Because
In fact, one of them asked for 8 months.
yes,
So your lordship,
let it be 30th August. They won't need to come back.
Perhaps.
Yes, my lord, 30th of August may be more realistic. With a game plan, we ought to continue with the appointees who were found to be void.
Were appointed.
Yes.
And they were not.
Their appointments were declared void by this.
They have to be shown the door.
I am not with that. But Lord, their appointments were declared void by the.
There is no need for them to come rushing back.
And they will,
Or if 31st August, or in the event the process is completed prior to that date, whichever is.
Let it be perempted. Let it be perempted. And it not continue like this.
and they will,
Appointments
they will
found
continue.
illegal, they will continue like this.
We make it clear that the teachers already appointed, who were permitted to continue till 31/12/2025, shall continue to hold.
So great.
Till the said.
They were supposed to
Very
give.
good. Tainted people are getting job.
That's not correct.
That does not come to
All
light.
list has been.
Ask the High Court to look into.
This is the only thing they can
I
do.
wanted to ask to declare.
I was appearing in 45.1.
Please, Your Lordship, I'm appearing in 45.1.
45.1, your application is defective.
Your Lordship, liberty may kindly be given to approach the High Court. As Your Lordship passed the earlier orders, because Your Lordship have
We find that defective and steps have not been taken to
Yes.
defects there. The application is accordingly dismissed. Dismissal of this application shall however not preclude the applicant from invoking appropriate remedies available to her,
Your Lordship,
if any, in accordance with law. Your prerogative is ridiculous. In a course that you have not joined, you want to be now permitted to join.
Your Lordship is permission and before Your Lordship. Because the whole selection of process I come inside, Your Lordship.
Where have we?
Not allowed to approach the High Court, whatever the decision.
I not will not enforce the application of the tainted.
Your Lordship, 45.1.
In Bengali,
Very well, we won't say anything now. A dismissal of this application anyway, we are doing it on the technical ground, so we don't have to give you liberty now.
Mulad, in Bengali there is a word.
My lord was
In Bengali there is a word, Otritto Atta. That means
That's the tongue twister. We
unsatisfactory
cannot
soul.
say it.
Unsatisfactory soul. Mulad, they are having that unsatisfactory soul. What?
Yes, not illegally appointed people who
How is it
continue.
pronounced again?
Otritto Atta. Tritto, Otritto Atta. Otritto Atta.
Whether the constitutional court found this illegal and they want to continue.
Every day, these unsuccessful persons, like 2006.
Who are unsuccessful? Illegally appointed persons.
Unsuccessful persons.
How can they not get
All this is not required.
Next.
Your Lordship, allow me point. My Lord, in row I may want you here.
Next matter.
Row I may be allowed to say. My Lord, in 45.1, I want to
Give
make
you
a
liberty. We've dismissed it on the ground that you did not cure the defect.
Your Lordship, sudden of this matter come. Allow me to.
That doesn't mean that you have.
Your Lordship, I'm in a process. I have filed the document.
7 days is what is given, is it not?
Your Lordship, allow me. Your Lordship, allow me. This matter not to be dismissed. Let it become on the next date of. Time is given. Your Lordship. My lord, my lord, it's a black point on me. It's a black.
Want us to dismiss it on
Lordship
merits?
may
We'll do
dismiss
that.
on merit, but if it is a black point on me, your lordship will dismiss on because I'm in a process. I have filed all the documents.
You want to go before another authority, do that.
Your lordship,
No question.
you kindly observe in that order. Your lordship,
No, we are not going to open doors.
the lordship, your lordship, I.
Not going to open doors. for
Your
you.
lordship,
May I indicate one thing?
suppose that any.
We are very much against judicial incontinence, which we find that has been a malady.
To dismiss,
Without
suppose that the one
this
defect is not being
judicial
your lordship,
incontinence not
may
warranted.
disturb to my sense, your lordship.
Not necessary.
Your lordship, not to, my lord, kindly.
Over council, not next matter.
Commit physical appearances.
Physical appearances, yes.
Physical appearance.
Number 46.
in 46,
I have been hearing these studio green matters since the day I came in with Dr. Singhvi, with Justice Dinesh Maheshwari. So since then, you've been leading them up the garden path without paying the money.
I'm very sorry to you. I didn't know Lordship has got a track record of my track record. I'll tell you why this may not be that case. Nobody told me that your Lordship is familiar with my past conduct. Now, it's just 2 minutes I'll take. This may not be warranted. I don't know what your Lordship other cases. And your Lordship will, I'll be very open about it. I'll tell you. Just don't open the pages, brothers. This is a
If
film.
you do, it will be worse.
No, I'll tell you why there is a solution possible.
Yes.
I think it helps nobody to do what is done now. I have got police 10.35 crores decree. Admittedly, I paid all of it. Interest is levied at 18%.
Whatever you have
that.
That degree has become final. You
No,
can't
but
challenge it.
there is no agreement on indeed.
Whatever it is, that execution petition is now
Now,
pending. We can't
on my writing, they agreed to an OTS only on the interest part of 3.75 crores. Right, police?
And you didn't go through with it.
Now, Melis, that in January, because this film is held up, I couldn't go through it. I got
Look at the number of movies.
I've got draft today.
Since when?
I did not come to court, but just kindly give me, bear
Look
with
at the number of movies you've been releasing without paying their dues.
No, this
Police safety, build up.
This one.
Some of these names I can't pronounce. Tangalan, Tangua.
Let me explain. This is Veera Verithu. This is Veera Verithu. It is sold. How can you injunct the rights of an OTT buyer, Amazon, others, third party, 19(1) applies. Now,
Unless a gun is held to your head, obviously you won't.
No, therefore I am solving this. The OTS.
You get all those stakeholders to trust in you and lend you money.
Just allow me to place.
Then we'll deal with that.
Give me 2 minutes. I got the OTS which I wanted in January 25. Foolishly, I did not obey it, right?
Yes. Foolishly
Now,
being
allow me. I have got the draft of that OTS, the bank draft here in my hand, and I will pay whatever interest the Lordship says for that 1 year. How does it help to? No, how does it help to keep the film back?
Mercy appeal
No,
there, not here.
I will pay interest on my delay, which is 1 year. This is a 3 point. Well, how does it help anybody? Let us kindly see how does it help anybody.
Mercy appeal before
No, but the OTT rights, the satellite rights, film rights, all are injuncted. These are persons not heard, but the OTT person is not heard. Amazon is not
They have
heard.
no interest. That is the reason why you get them to lend you the money. If they are foolish enough to do that, then perhaps.
If I earn from this movie, it only helps the
we
creditor.
find no good ground and reason to interfere with the interim judgment passed by the High Court.
Can I do one thing? Can I make the no? Don't say that. I'll withdraw it.
We already said no more incontinence.
No, I'll withdraw it, and I'll go and make the offer because this.
Have you want to say?
No, I just
You will
I'll withdraw it.
then you withdraw.
No, I'm not sure record my statement because I wish to make the offer in a draft. That's all.
Having argued for some time, the senior counsel for the petitioner seeks permission to withdraw the special petition, reserving liberty to the petitioner to approach the executing court.
Yes, exactly.
Approach the executing court. Permission, don't say permission, man. Especially petition is accordingly dismissed. We, however, make no comment as to the other aspect with regard to how the executing court should deal with.
Your Lordship, a hearing matter, the other movies. I did not know
The
that.
petitioner.
Yeah.
Studio Green came in. This is Dinesh Maheshwari's court.
This I have learned
I remember.
just now that your Lordship.
I remember who appeared also. You did not appear at that stage. That's why
I
you
know
are
first
there.
time I thought this is the first before day.
And very aggressive arguments were advanced on behalf of Studio Green. But by now they
Quite
should.
foolish on our part, but we got a OTS of 3.75, they did not pay. That's why I have to get a draft first.
Item number 47.
Well, consumer forum has decided the matter pertaining to
This issue before the High
Yes,
Court?
my lord. Yes, my lord.
How does the High Court deal with it?
High Court has said there is an
Only
alternative petition appeal.
alternative. They don't
Yes.
deal with the issue of
No,
whether
no, my
this,
lord. No, my lord.
and they asked you to go to the district consumer. I was wondering whether Allahabad has a different hierarchy under the.
No, there is a appeal. There is an appellate.
Go to the
State.
state commission.
Yes, my lord.
I was wondering whether there's a division, separate bench dealing with appeals from the consumer district forum itself.
Yes, my lord. But the thing is that the order was passed without jurisdiction. It is pertaining to the gratuity level. my lord.
Issue notice returnable on 16th March. In the meanwhile, what is the order?
My lord, they have filed a
The district forum's order.
Yes, ma'am.
4425. Is that right?
My lord,
4425.
complaint number 33224.
What is the date of the order comes?
425. Yes, ma'am. Yes, ma'am.
In the meanwhile, the order dated this 4/4/2025 passed by the District Consumer Dispute Redressal Commission, Jhansi.
Jhansi.
In
Uttar Pradesh.
Oh, no. Case number.
Complaint number
33
of
of 2024 shall remain still.
Because I'm seeking regular bail in this matter. Because I'm in custody for the last 2 years, 5 months and 28 days as of today. Without a trial, because the charges were framed on 3rd of April 25.
Don't issue notice, returnable on 29th January.
I'll be grateful.
Lord, your lordships directed the High Court to hear the matter on merit.
Is it the fact that these 29?
No, on the contrary. No, on the
Why
contrary.
does
I
the
when I
DMO go and say that again?
No, that is the problem. DMO was asked by the Chief Justice in the court. So DMO started making statements, forgetting that she herself has signed the report. So I have produced
But
that.
why did she make a statement?
Look, that's why she was given a show cause notice. So for giving show cause notice and seeking explanation, he issues contempt and says, come and.
But you ought to have asked for his permission then.
And can he sit on judgment, Lord?
You don't know how fragile our egos are.
That's the whole problem.
Then
when it was pointed out that High Court has been directed to hear the matter because there is urgency in the matter, he said, all right, then and instead of Lord hearing the main matter, starts with all this. How can you?
No, but what exactly is the situation with these 29?
No, 29 they've been given, Lord, they are out of 167, only 29 are given. And please see that report.
He seems to find fault with that. He says even
he says that was only a stock. It is not.
What did he say?
Showed him
non-existing fact.
Non-existing fact is pleaded.
What is a non-existing fact then?
Lord, that's their own perception with great respect.
Because I couldn't understand what he meant. Counter affidavit by P canvases of non-existing fact. What is a?
Lord,
did he elaborate on that?
No, not at all. Not at all. And he says issue notice to those petitioners who went by way of excellency.
Now he's initiated contempt proceedings.
Contempt proceedings. And Lord, he can't inquire into this whether how Apex Court passed this order.
Next month.
Next month. My lords.
What is the exact order he's passed on?
Look, 2 orders.
She says that no mining lease was given a clean sheet. Why did she say that then?
Lord, in fact,
did he report it wrongly or did she actually say that?
It is reported wrongly. Lord, in fact, what has happened is there is a report which is signed by her also. And that I have produced here. That is, Lord, at page 127.